Please come and join us. And Honorable Justice Maria Wimbe, if she's in the room, please come and join us. Please come and join us. And Honorable Justice Maria Wimbe, if she's in the room, please come and join us. That is IT. I'm not speaking, as you can see. I'm not quite sure what is happening. Without much ado, I will hand over the microphone to our keynote presenter.
Thank you very much, Justice. It's my pleasure again to share some thoughts on the topic that has been allocated for this session. I've been asked to, actually, let me read it as it appears, Justice, with the permission. Says, towards a common ground, forging shared values in the adherence to the principles of democracy on the African continent in relation to transparency. So I intend to do exactly that, but I've developed a particular framework around it so that I make sense. So I've recast the topic this way: transparency as a core principle of democracy. And in my discussion on that, I've been trained to use this. I hope I'll do the good job of it. I was just trained this morning to use this gadget. So please pray for me that I succeed to use it. Please, I need that prayer. So these are the things we're going to go through. I'll do a brief intro, Justice, very brief, and go through those issues. Transparency as a core component of electoral integrity. I want to bring the concept of electoral integrity again, because I think electoral justice may not succeed sustainably without electoral integrity. So that's why I want to bring the concept of electoral integrity to our discussion in a big way this morning. Then I'll bring the AU, because we are here discussing the African Charter on Democracy, Elections and Governance. I'll bring that charter. I'll bring the AU norm on electoral integrity for our attention. And I'll then zero in on the challenges before I suggest briefly a way forward, Justice. That's the way the presentation will flow. By way of introduction, Justice, let's start with the concept of transparency. And here I'm literally, it is not my definition. That's why I put it in inverted commas. I'm literally actually citing a dictionary, a simple dictionary definition of transparency. The quality of easily being seen through. The quality of easily being seen through. That's transparency. Slightly different definition, but more or less put slightly differently, but the same definition. The quality of allowing light to pass through so that objects behind can be distinctly seen. This is the transparency in simple terms. Transparency, therefore, is the cornerstone of democratic electoral governance. It is then central to the notion of, I want to introduce this notion: procedural certainty and substantive uncertainty. It's not my concept, it's not my notion. That's why I've quoted it also. It's a concept that was popularized in the early 2000s by one professor from the US. His name is Shaheen Musafa. Shaheen Musafa popularized this, so it's not mine, but I find it very useful because it is central to democratic electoral governance. And I'm emphasizing democratic electoral governance because, as we said, I think there's one of Justice from Malawi, CJ from Malawi, just reminded us a while ago when we were recapping, Arnold, that we should also not equate elections with democracy, right? So it is important to also make a distinction between democratic electoral governance and autocratic electoral governance. So transparency is the core of democratic electoral governance justice. So that's the point I want to make. So we judge the quality, the democratic quality of elections on the basis of the extent to which that election lives up to the notion of procedural certainty and substantive uncertainty. What does this mean? The notion denotes that all legal, sorry, you see now, that's why I needed a prayer. So I've got it now. This notion denotes that all legal, regulatory, and procedural aspects of elections must be transparently known. Transparency comes back. Transparently known before, during, and after the elections by all key stakeholders. That is the essence of procedural certainty and substantive uncertainty. That's the procedural certainty part. The substantive uncertainty. So this is what then defines the procedural certainty. Now let's go to the substantive uncertainty. This notion denotes that the outcome of elections in the form of election results should be known only after the elections, following the announcement by the electoral management body. So the procedures should be known well in advance, but the substance of the election, i.e. the result, should not be known before the EMB pronounces. That's the notion. It's as simple as that. And you can tell that in that notion, much as we are centering electoral integrity, we can also bring back electoral justice. There cannot be electoral justice if there's no procedural certainty and substantive uncertainty. And no doubt about it. No doubt about it. Now, I hope this is clear. I'm not quite sure whether you can see that picture there. That picture is what is often referred to as the electoral cycle. This is the electoral cycle in its fullness. This is the electoral, in its completeness. This is the electoral cycle. That each and every election has to go through. This what entails an election from A up to Z. Now, I don't want to take a lot of your time. I want to just to, it's like it's going for work. This is what I want. So I want to just to, let's focus on the inner circle only for our purposes. So the electoral cycle is the legal framework, planning and implementation, training and education, voter registration, electoral campaign, voting operations, verification of results, post-election processes. This is what an election entails. Literally, all EMBs know this. Now, that notion of procedural certainty and substantive uncertainty says that the laws, regulations, and procedures must be known, transparently known by all key stakeholders, all the way, from legal framework up to the end, post-election. They must be known in advance, transparent. However, that notion also says, but the results should not be known until the verification and announcement by the EMB of the results. Now, this reminds me of a very interesting story of some colleagues, Justice Rita, who were at the conference. So during lunchtime, the conference was on elections, obviously. During lunchtime, so they were having lunch together, the three of them. One was from one was from the Americas, another one from Europe. Let's not bother about the countries, the America and Europe. Another one was from Africa. Let's not even mention the country for the sake of protecting its own image. So these colleagues discussed, and the one from the Americas said, you know, guys, we're wasting a lot of our time in that conference, discussing democracy, elections, and all that. You know, we just need to close this conference and tell all the participants, all you need to do is to look at the US. Look at the US if you want to learn about democracy, elections. Then the other one, why do you say so? Was in the US, he said, in the US, we know election results 48 hours after the election itself. Oh, is that the case? Then the one from Europe said, in that case, it was from the UK. My friend, if that is the yardstick, no, you all should look at the UK. Let's close the conference. Just look at the UK. Because in the UK, we know results 24 hours after elections. Then the one from the continent said, in that case, colleagues, you better look at our continent. In Africa, let me tell you something that you probably don't know. If that is the yardstick, in our case, we know results 7 days before. 7 days before, we're clear. We are clear. Who is the winner? Who is the loser? We're very clear. So stop this thing. Let's just close the conference. Let's just make a closing remarks at the conference that just look at Africa and that's it. So that story, it may look like a joke, but that story speaks volumes regarding a procedural certainty and substantive uncertainty. That in most instances, actually, results are known ahead of the announcement by the EMB, and that procedures are less known. They are a secret that is confined to mainly the political elite. So we need to clear that. We need to actually just sort that out to bring democratic governance, electoral governance back on track, to stick to the notion of procedural certainty and substantive uncertainty. Let's go to the AU norm on electoral integrity. Electoral integrity, in simple terms, denotes any election that is based on the democratic principles of universal suffrage and political equality as reflected in international, continental, and regional standards and norms. That's what integrity entails. It is an election that is managed and administered professionally, impartially, and transparently. I bolded transparently, deliberately, because that's the focus of our discussion. Throughout the three stages of the electoral cycle that I showed in that diagram earlier on. The AU norm is clear. Or before I get to the norm, let me just highlight the principles of electoral integrity. The principles are very clear also. There they are. And they touch a lot on what we have discussed with regard to electoral justice. So you can already see the synergy between electoral integrity and electoral justice. So electoral integrity, constitutionalism, rule of law and justice, ethical conduct, these are the principles. Impartiality and independence of the EMB, accountability, level playing field and fair treatment of all stakeholders, legitimacy of the outcome. Yes, that has to be known at the end, not 7 days before. Now, the AU norm, there it is, Justice Makarao, there it is, 2002 AU Declaration on Principles Governing Democratic Elections, which we spoke about earlier on yesterday, and the 2007 ACDEC that we are focusing on, provide that democratic elections should be conducted and I take this verbatim from the charter itself, freely and fairly, under democratic constitutions and in compliance with the supportive legal instruments, under a system of separation of powers that ensures, in particular, the independence of the judiciary, at regular intervals as provided in the national constitutions, and finally, by impartial, all-inclusive, competent, accountable electoral institutions staffed by well-trained personnel and equipped with adequate logistics. That's the AU norm. So the question then is, in our own assessment, to what extent are we adhering to this norm in practice? And yesterday, we reminded ourselves that this year, we have 24 elections lined up on the continent. 24 elections. That is presidential, parliamentary, and local. Taken together is 24 elections. So the question is, to what extent are these elections lined up for this year going to adhere to this norm? Before I conclude with the way forward, let me just highlight a few challenges. There's a book, I'm not sure how many of us have come across this book. It's 2018, strikingly entitled, How to Rig an Election. I'm sure you'll be interested, all of you, I'm sure. You'll have an interest in reading that, How to Rig an Election. And that book summarizes some of the challenges that face electoral integrity on our continent, basically. And I want to list them. It says gerrymandering is one. That is, gerrymandering. That's boundaries. Manipulating electoral boundaries. Gerrymandering. Vote buying is one of them. Repression is another. Hacking the elections is another. Ballot box stuffing is yet another. Playing the international community is another. So these are the strategies that have been used and perfected over time to rig elections and on our continent as well. So we need to be mindful of this. But the rigging has become sophisticated lately because it now entails technology. How to use technology to manipulate elections. So we have to be mindful of with the onset of digital and social media. We have to be mindful of that challenge also of misinformation and disinformation. We also saw the challenge that was posed by COVID-19 for our elections. I don't need to belabor that point. Now, let me conclude, Justice, by suggesting 5 points as the way forward. First, to deepen electoral integrity and electoral justice. Now I'll take them together. There is need to ensure institutional strengthening of independent EMBs and the judiciary. We've said this, but I want to highlight it again. There's need for strengthening EMBs and safeguarding the independence of EMBs and the judiciary. 1. 2, ensuring the effectiveness of election-related dispute resolution mechanisms, both formal and informal. We have said this, but I want to re-emphasize it again. 3, entrenching intra-party democracy. We have not touched on this, but it's a very important issue. Because political parties are the key players in elections, but they are the poorest performers in terms of internal elections themselves, within themselves. So the conflicts that mark intra-party elections, oftentimes also spill over into the elections at the national level. So we need to really give what's the word? Have a particular focus on political parties, even the internal arrangements, as it were. Promoting inter-party political tolerance anchored on dialogue. These parties are poorly organized internally, but to make matters worse, to pour salt onto the wound, they don't relate well to each other. The ruling parties don't relate well with opposition parties. That needs to be sorted out through mutual dialogue, mutually beneficial dialogue that should engage, should mark their constant consultations and conversations. Finally, institutionalizing civic and voter education through formal and non-formal education system. That's important also, because that would also empower the citizens. I think in our caption this morning, we emphasized the point was made, I think by my good friend Arnold, that the voter should be the focus of democracy, the focus of election. But if the voter does not know, is not empowered with knowledge, then the voter would not know what to do, or the voter will simply opt to stay away. Hence, low voter turnout in our elections. Justice, that's what I wanted to share with the audience. Thank you so much. Thank you so much, Justice.
As usual, another round of applause for Dr. Matlosa. As usual, he kept us captivated and he set us thinking. Without much ado, I want to call upon the respondent, Justice Daniel Musinga. He is the president of the Court of Appeal in Kenya, and he is also the vice chair of the Judicial Committee on Elections. I do not have his detailed biodata, but will ensure that it is part of the documentation that goes out to delegates at the end of the conference. I'll call upon you now, Justice Daniel Musinga. 5 minutes.
All right. I'm told I have 5 minutes, but I don't know. We'll see. I want to start by sincerely thanking Dr. Matlosa here for very engaging our remarks. I wish we had time to just listen to you more, but we will have an opportunity during the plenary. As you were told, I will be making very few off-the-cuff remarks. In my capacity as the vice chair of the Judiciary Committee on Elections. And basically, what I am discussing is the Kenyan experience at improving transparency and building trust in election adjudication process. Now, I want to put a caveat here that it is in the context of the Kenyan judiciary, because there are things that I will not be able to touch on. Yesterday, you had Justice Isaac Naula, a judge of the Supreme Court of Kenya, addressing us or telling us about how lack of public confidence in the judiciary contributed to the post-election violence that hit our country in 2007. And following promulgation of the 2010 Constitution, which put a heavy premium on the importance of free, fair, transparent elections, the judiciary took various steps that were aimed at restoring public confidence in the judiciary. Because as he said, the main opposition parties refused to go to court because they say they had no confidence in what was going to be done by our courts. And as we all know, and it has been said time and again, election is not an event, it is a process. And that cycle that Dr. Matlosa has showed us is very, very informative. There are pre-electoral, electoral, and post-electoral events that impact upon the people's level of trust in adjudication of electoral disputes. And to engender public confidence and trust, there has to be transparency throughout all those processes. I shall highlight various measures that the judiciary put in place since 2012 to improve transparency and build public trust and confidence in our electoral dispute resolution. In May of 2012, Chief Justice Dr. William Mutunga set up Judiciary Working Committee on Election Preparations as an ad hoc committee. And I'll highlight briefly the mandates of this committee because its mandate ties in very well with what I will be discussing and what has been highlighted here by Dr. Matlosa. Five-fold mandates. Number one, to advise the judiciary on the administrative arrangements and measures for the efficient disposal of election-related disputes. Two, to develop and implement in conjunction with the Judiciary Training Institute a training program for the efficient and effective management of election disputes for judges and magistrates and support staff. Three, to support and design a system for monitoring and evaluating the management and administration of election-related disputes in courts. Four, to liaise and coordinate with the stakeholders to ensure efficient, effective, and timely resolution of election-related disputes and offenses. And lastly, to advise the judiciary on the information to be developed and disseminated to the public on the avenues open to it to pursue electoral disputes and the approaches that will be employed. The work of this committee, ladies and gentlemen, through various interventions that I shall shortly highlight, has restored public confidence in Kenya's judiciary. And in view of the overall success in the work of this committee, in 2015, the Chief Justice made this committee a standing committee in our judiciary. And the membership of this committee is drawn from all levels of our courts, from the Supreme Court, the Court of Appeal, High Court, and the Magistrates' Courts. And the committee has a secretary who also heads the secretariat, and the secretariat has various people like researchers and other support staff. And so what has this committee done over the years towards improving transparency and building trust in election adjudication process? And I'm proud to be talking about these things in the presence of Chief Justice Emeritus David Maraga, because he was the chair of this committee, and as a Chief Justice, he also ensured that the committee was well resourced to undertake its functions. I will highlight some of the things that the committee has done through which the judiciary has been able to gain or to regain public trust. The first one is amendment to the legislative framework on EDR and establishment of the political parties disputes tribunal. The JCE identified various laws that needed to be reformed in order to facilitate the constitutional imperative of timely resolution of electoral disputes and to create consistent, transparent, and comprehensive framework ahead of elections. The committee engaged with various stakeholders like the Independent Electoral and Boundaries Commission, the Justice and Legal Affairs Committee of the National Assembly, the Law Society of Kenya, the civil society, and the other relevant stakeholders. We looked at all the various amendments that needed to be made, and through the intervention of Parliament and these other stakeholders, we were able to see very many amendments put in our laws that enhanced transparency in electoral process. I do not have time to give you examples. Let me talk briefly about the establishment of the Political Parties Disputes Tribunal. You have heard what Dr. Matlosa say that some of these disputes start long before the electoral process. Indeed, it is true. So this tribunal was brought under the judiciary, and the tribunal has been able to determine thousands of nomination disputes very expeditiously, and appeals from these political parties disputes, appeals from this PPDT come to the High Court. The second thing that I want to highlight is publication of election dispute bench book and compendiums on electoral decisions. It was important to prepare this, what I may call the gray book, as a quick reference material to enable judges and magistrates to have something that they can quickly look at in the process of doing elections. And we have distributed these books to all judges and magistrates that undertake that here election petitions. Number 3, conducting ADR trainings for all judges and magistrates and select judicial staff. What do we do in these trainings? Many things. We teach judges and magistrates, or we refresh them on how to craft proper judgments, summarize them, make sure that we do not dwell on unnecessary technicalities in determining these election disputes. We bring scholars, renowned practitioners, and civil society to critique our judgments. We look at our judgments, we critique ourselves, and we agree that we want to develop a coherent, transformative, and transparent jurisprudence. Jurisprudence that is devoid of unnecessary legal technicalities. After we have had all the election disputes, we have deep brief sessions where we bring together all the judges and magistrates who had election disputes, so that we can think through the work that we've done, share important lessons, and document those lessons. And these debrief notes and sessions have been very, very helpful. And I must really thank the various development partners like LGR, ICJ, who have assisted the committee in developing this material. Number 4 is voter education and outreach talk shows that we do prior to and after elections about the role of the judiciary in EDR, assuring the public that the judiciary is well prepared and ready to handle election disputes. We have also done publication and dissemination of pamphlets that answer frequently asked questions on EDR. We even produced a documentary prepared by the Public Relations Department of the Judiciary in conjunction with my committee, that was able to be aired, and it explained to the public all these things that relate to determination of these electoral disputes. And we circulated new election petition rules in the daily newspapers and the judiciary website. Number 5 is engagement with relevant stakeholders like political party leaders, electoral management bodies, the law society, and the civil society on relevant EDR issues, because these are key players, and we cannot be transparent if we do not involve such stakeholders. Number 6, engagement with poll observers before and after the elections. We had very many political poll observers that came to our country before our general election in August. And we engaged with them as a judiciary, and they explained to them all that we had done in terms of preparation to handle these election petitions transparently. And even after the elections, we had sessions with these poll observers. Number 7, engagement with the media. explaining the EDR procedures and processes. We've done televised hearing of presidential election petitions in the Supreme Court and broadcasting of proceedings on various radio stations. Thank you. I have 3 more minutes. Our presidential election petition, the hearing, was live streamed on even on various social media platforms, including Facebook, YouTube, and Twitter. We also do regular media briefings on all important ADR issues. Number 8, we have ensured expeditious disposal of electoral disputes by all the courts. You heard Justice Lanaola say that the Supreme Court has 14 days, the High Court has 6 months, the Court of Appeal has 6 months, and I'm happy to say that none of these courts has ever defaulted in meeting its timelines. All election petitions have been dealt with and disposed of timelessly. Number 9, expeditious dissemination of all decisions on electoral matters by our legal researchers that are based at the Secretariat. Our researchers pick these judgments immediately they are delivered, upload them on the judiciary website and dispatch them to the Kenya National Council for Law Reporting, so that judges who are doing those matters are able to pick the decisions and pick the lessons and apply them in matters that they are still handling, and the public is informed and they get to know about the determination as quickly as it happens. And the last thing is I'll talk about is electronic filing and virtual hearing of election petitions. In this last election cycle, all the petitions that we handled were filed electronically. In the Court of Appeal, we had all of them virtually, and in the High Court, it was a mixture of both, you know, in person and some were had virtually. In conclusion, my brothers and sisters, ladies and gentlemen, this is what I would like to say. These are the main initiatives that have been put in place to address EDR chain gaps in order to enhance transparency and public confidence in the election adjudication process. And as a result, let me give a summary of what the AU and COMESA election observers mission concluded after the 2022 presidential election. They say this, and I quote, "The judiciary played a critical role in guaranteeing the right to a fair and expeditious hearing, which increased citizens' trust and confidence in the electoral process," unquote. And similarly, the European Union Election Observation Mission stated, and I quote, "There is generally a high level of public confidence in the judiciary. There was a concerted and successful effort by the courts to process electoral disputes expeditiously," unquote. Thank you very much for listening to me.
And thank you very much, Justice Musinga, for heeding my call to wind up in 3 minutes. I actually felt very small having to call upon him to wind up, but I'm also time bound, like in dealing with election petitions, we are time bound. The main thrust of the Justice Musinga's presentation has been how to enhance confidence and trust in the judiciary, and he has shared with us the Kenyan experience. And I need not remind you, colleagues, that the statistics we received yesterday showed that we are number 3 after the first one are pastors. They enjoy the highest level of trust and confidence. Second is the army, then traditional leaders, and then we are number 4, but at least we are ahead of the EMBs. I now want to call upon Honorable Justice Maria Kawimbe to lead the panel discussion. She needs no introduction. She has been before you. She was here yesterday.
So good morning again. I am here to, I'm using a PowerPoint presentation. This one.
In view of the technology hitch, we will go on to the next panelist, who happens to be Felix Awuo. When I introduced him, I said I call him Felix because him and I go a very long way. We observed elections together in Rwanda, Kigali, in 2014, and he was my technical advisor. You are in very good hands. Come.
This button for the next slide. This one, previous slide. Okay.
Thank you very much, my lady. Yes, indeed, we go back a long way. The Honorable Lady Justice headed the AU mission in Rwanda, and I was privileged to be a technical advisor, the African Union Election Observation Mission. Ladies and gentlemen, allow me to associate myself with the protocol that was established, save to acknowledge the presence of the host Chief Justice, my Lord, the Chief Justice of Zimbabwe, and visiting Chief Justices of the Republic of Zambia, as well as the Kingdom of Eswatini, but also to acknowledge the presence of Chief Justice David Maraga, Chief Justice Emeritus of the Republic of Kenya. I work for an organization called the Electoral Law and Governance Institute for Africa, which is a regional organization that supports democratic governance, electoral institutions. And we take pride in the fact that one of our key programs is a support to the judiciary on electoral dispute resolution. And we have worked very extensively and very comprehensively with the Kenyan judiciary to the level that the judiciary of Kenya is free, especially on matters electoral dispute resolution. In sometimes back in 2019, the African Court on Human and People's Rights, recognizing the prevalence of electoral disputes, prioritized the fourth judicial conference that was held in Kampala on understanding the resolution of especially the presidential disputes and the emerging jurisprudence. We were tasked during that process to look at what are the key issues that have been emerging with respect to the resolution of presidential disputes in Africa, and what are some of the comparative electoral law jurisprudence that have emerged across the various jurisdictions. A lot has been said, and I will not repeat from yesterday's keynote, to the opening ceremonies and indeed other things that were mentioned. But allow me to flag out two things. The first is that when we looked comparatively at elections in the continent, we recognized that despite the fact that this continent has been independent since the late 50s to early 60s, over 60 years ago, and since the continent by and large is a multi-party democracy following what was christened as the second liberation, elections in the continent are continued to demonstrate or to reveal certain challenges. And our analysis led us to conclude that the dominant problem comparatively was a phenomenon called the inconclusive electoral cycle. Simply put, it denotes a situation where elections held in different parts of the continent reveal certain shortcomings and challenges. The same were not conclusively addressed, and then they were subsequently imported to the next elections. And that explained two factors. One, that elections, Africa or majority of the countries are permanently in an electioneering campaign. If you go to Kenya, for example, right now, you would be excused to imagine that we're having the next general elections, which is, by the way, is in 2027, next week. We're already in a campaign mood, and that exists just about in every country. The second factor was that the elections reforms or electoral reforms are either skewed or outrightly stalled, with the resultant effect that electoral integrity then becomes into question. And that explains also the concept that Kabele talked about on the judicialization of politics and the politicization of the judiciary. The point is that as long as the election continue to have questions on integrity, then the judiciaries in Africa will be called upon to adjudicate and to make a determination on the efficacy of those elections. The other factor that we during that study that emerged was the fact, and let me just go straight, use my paper to save on time, that in Africa, the constitutional and legal framework provided for electoral dispute resolution comparatively across the country, whether it is Kenya, Zambia, Malawi, Nigeria, Ghana, with the exception of Tanzania, that hosts the jurisdiction of the judiciary in determining the electoral dispute by providing that the decision of the Electoral Commission is final. And this was challenged in the African court, in a case called Jebre Kambole versus the United Republic of Tanzania. And it was established in Tanzania by the court that particular provision militated against the access to justice principles. During the study on the presidential petitions in Africa, and now going towards some of the key emerging jurisprudential issues. During that study, we found that the main problem that the judiciaries faced was with respect to probably the most important jurisprudential issue that is called the substantial effect doctrine. This law emanates from the English law, the Representation of the People's Act, at section 23. And it states, and I quote, "No parliamentary election shall be declared invalid by reason of any act or omission by the returning officer if A, the election was so conducted as to be substantially in accordance with the elections, and B, the act or omission did not affect the result." Now, the substantial effect doctrine has proved problematic and challenging to most judiciaries across Africa. And the interpretation that has been taken by the Supreme Courts in Africa and the constitutional courts, that before an election is invalidated, both conditions of non-compliance with the provisions of the law and affect substantially the results of the elections must exist together. It is not enough to establish evidence of fraud, but such evidence must affect substantially the result of the elections to warrant the court to invalidate the elections. The substantial effect doctrine, as I'm sure all of us know, was elaborated by Lord Denning in the famous case of Morgan versus Simpson, where he came up with 3 parameters, which in the interest of time, I will not be able to talk about. But let me take you through the conundrum that is faced by the judiciaries across Africa in unpacking or interpreting the substantial effect doctrine. Number one, one of the questions the judiciaries are grappling with is, what is the threshold for invalidating an election on the basis of irregularities and illegalities? And connected to that, do irregularities and illegalities have the same legal weight? And I will be able to persuade you that substantial irregularities and substantial illegalities do not result to the same effect. Majority of the judiciaries in Africa have treated them as one and the same thing. The difference is on this between substantial irregularities or an error in an election is on the impact, whereas the difference on the test for measuring substantial illegalities is the substantiality of that illegality and not its demonstrable impact. The second question or conundrum faced by the judiciary is, what is the proper legal interpretation of the substantial effect doctrine? Does it require a conjunctive or disjunctive interpretation of the Constitution and on election laws? And I will be able to take you shortly on some of the approaches that have been taken by the various courts. The third issue is whether election is a qualitative or a quantitative process. And finally, what is the technical meaning of affect the results in law? Now, if you look at the problematic nature of interpretation of the substantial effect doctrine, is evident on the certain decisions that were taken by the judiciaries. In the Nigerian case of Buhari versus Obasanjo, the court admitted evidence of elections fraud to include massive fraud, violence, intimidation, and inflation of election results, and the EMB refusal to tender before the tribunal the certified copies of the presidential polls, among others. Despite this, the court ruled that the extent of the fraud did not affect the result, and therefore it was not sufficient to invalidate the elections. In the Uganda case of Skiza Besigye versus Yoweri Museveni, the judges of the Supreme Court of Uganda took the same approach, where despite the fact that the judges unanimously held that the election was marred by disenfranchisement of voters, by unlawfully deleting their names from the voters' register, wrongful counting and tallying, bribery, intimidation, violence, the court held that in determining whether the court should invalidate the elections, numbers were the sole measuring yardstick. And to the extent that the difference between the winning candidates, President Museveni and Besigye, was 1.58 million votes, nothing that the petitioner did would upset that numbers, and that therefore the election stood. And the reasoning about numbers, again, was repeated in the Zimbabwe case of Chamisa versus Mnangagwa, where the legal philosophy that even if there was non-compliance with the law, as long as the results were not affected, the election could not be invalidated. Now, in the Zambian case of Anderson Kabele Mazoka versus Levy Patrick Mwanawasa, the Supreme Court of Zambia, while accepting that numbers was the sole yardstick, then legislated an additional criteria, and that is the evidence of illegalities and irregularities needed to also demonstrate or have a geographical spread. In other words, the petitioner needed to demonstrate that they were widespread and across, presumably, across the Republic of Zambia. Now, the decision, if you look at the jurisprudence in just about every African court, they seem to elevate and make prominent numbers as the measuring yardstick. In other words, the quantitative aspect of the elections as opposed to the qualitative. Now, this decision, this jurisprudence departs the decision taken by the Kenyan Supreme Court in Raila Odinga and the decision taken by the Malawi Supreme Court in Arthur Peter Mutharika departs from this criteria, this jurisprudence, and correctly restates the role of the court, which is fidelity to the Constitution and the elections law. That in the both cases, the Supreme Court came to the conclusion that a petitioner, if an election demonstrated substantial, or if an election was held substantially in a manner that did not comply with the law, and that there were illegalities and irregularities that were committed, then the election could be invalidated irrespective of the result. The Supreme Court of Malawi stated that the Zimbabwe case of Chamisa versus Mnangagwa and 24 others seems to suggest that as a general rule, an election will not be annulled if the breach of the law did not affect the election result. We have doubts that this would be a good approach, particularly where serious breach of the law is involved. What if the numbers themselves are as a result of an inaccurate counting, intimidation, fraud, or corruption? So this is the decision that was taken, or this is the jurisprudence that was taken by the Supreme Court of Malawi and the Supreme Court of Kenya, that led to these two courts as the only courts that have been able to invalidate a presidential election, because they correctly stated and appreciated the fact that illegalities or substantial illegalities and substantial irregularities constitute separate grounds for invalidating an election. Very quickly on the second jurisprudential issue, if one of the things that we found in the study was the different approaches by constitutional courts and Supreme Courts in Africa on the single question on the burden of proof, as well as on the standard of proof. Now, in the common law of evidence, if we start with the burden of proof first, it has been now jurisprudentially settled that he who alleges must prove. And this seems to be the position that is adopted by just about every court in the continent. Now, the initial burden is on the petitioner to prove that the election was held substantially in a manner that did not comply with the law. But once the petitioner has discharged this initial burden, then the burden therefore shifts on the respondents, most cases the election management body, to reissue the necessary rebuttals that election was held or that the Electoral Commission complied with the law. The justification for this is that in every election, the election management body is a respondent. And in every election, unlike in other suits, the best evidence in terms of the electoral materials, the ballot papers, the statutory declaration forms are in the hands of the Electoral Commission. And therefore, it is only fair to have this burden shift. Now, if you look at the Kenyan case, the Kenyan Supreme Court and the Malawi Supreme Court and followed it, you can clearly see how the Supreme Court compelled this burden to shift on the Electoral Commission. Now, for jurisdictions where the sole yardstick is numbers, it is very difficult to tell whether this evidentiary burden actually shifts to the respondent, and in particular, the Electoral Commission. The third issue is on the standard of proof. On this issue, the continent is split. There are two schools of thought that seem to take the Kenyan judiciary approach and the other school of thought that follows the Malawi Supreme Court's approach on the question of the standard of proof. Now, in ordinary civil cases, as was stated repeatedly, the standard of proof is on a balance of probabilities. Now, in 2019, in Lewanika versus Chiluba, the Supreme Court of Zambia, quoting Ngulube's Chief Justice as he was then, came up and coined the terminology that the burden must be discharged to a high degree of convincing clarity. What they suggested, and it was adopted by Uganda in the Kiza Besigye case, and later by Kenya in Raila Odinga case 2013 and 2017, that because of the sui generis nature of electoral disputes, the appropriate standard of proof has to be an intermediate standard. That is a standard above the civil standard and a standard below the criminal standard or beyond reasonable doubt. The countries that follows this jurisprudence is Kenya, Zambia, and Uganda. In Chamisa versus Mnangagwa, the Constitutional Court of Zimbabwe rejected this notion and stated that the appropriate standard has to be the normal civil standard. And this was repeated first by the High Court of Malawi and thereafter endorsed by the Supreme Court of Malawi, where they rejected the Kenya, Zambia, and Uganda jurisprudence and appropriately located the standard of proof as requiring the proof, the civil standard of reasonable doubt. The reasoning by the Supreme Court of Malawi was that an election is a right-centric, that you can therefore not impose a higher burden on the petitioner beyond the burden that is required to be discharged. And the Constitutional Court of Zimbabwe rejected the Kenyan argument of the sui generis or the peculiarities of the electoral petition, stating that there was it was bad law to solely base the sui generis nature of the petition or electoral petition as requiring a standard that is beyond standard of proof. As I conclude, I'll seek the indulgence of my lady to allow me to play just one clip to underscore as I conclude. Now, let me conclude by scrutiny. If you look at the approaches that have been taken by the courts in the continent with respect to scrutiny, the first is to appreciate that in common law jurisdiction, petitions are very adversarial in nature. The judiciary usually play a passive role and just sit during the petition. Now, the Supreme Court of Kenya departed from this jurisprudence in especially the 2017 case that was presided over by Judge Maraga, and came to the conclusion that in as much as it is an adversarial process, and given the political issues that an electoral petition raises, the judiciary must adopt, or the Supreme Court must adopt, an inquisitorial approach, especially to get into the issues of the substantive issues that were raised. In that regard, the Supreme Court of Kenya in 2017 ordered on its own motion certain scrutiny of electoral materials, whether they were statutory forms 34As and things like that. Now, the advantage with this, especially for countries like Zimbabwe, Zambia, and Kenya that have time-specific, that electoral petition must be resolved within 14 days, it helped substantially on getting into the substantive issues, but also then dealing with the questions of the merits of that case beyond what was tabled as evidence by especially the Electoral Commission. So the Kenyan Supreme Court ordered scrutiny on the ballots, on the forms, and made very specific orders on the election technology which was deployed by Kenya. Now, this is contrasted by, say, for example, the Constitutional Court of Zimbabwe in Chamisa versus Mnangagwa, where part of the reason why the petition was dismissed was the inability by the Supreme Court, by the petitioners, to produce primary evidence in the form of ballots and statutory declarations, Form 7, I think that is what the forms that are used in Zimbabwe. Now, to look at this thing, and I want to just request just a minute, just to show this video. I don't know whether it's ready. If it's not ready, I'll go and see it. Now, these are the approaches that have been taken by the constitutional courts and the Supreme Courts across Africa. Now, to appreciate this, look at the approach on these issues.
With regard to what you said about regulations 79 and 83.
Yeah.
That there were no security features required on these forms?
It is not a requirement of the law.
It is not a requirement of the law?
No.
But did these forms have security features?
Yes.
So meaning if they had, they all should have?
Abundance of caution. The commission, out of abundance of caution,
yes,
are the ones who designed the security features.
Okay.
Yes. And my Lord, we have explanations. It's just that there wasn't enough time. Because when you scan a copy, you can actually lose some of the security features. But all I'm saying
Mr. Mita, before
is
you
that
move-
the
before-
forms
Mr. Mita,
34, yes,
before you move,
yes, my lord.
how do you explain Nyali in that form? And the serial number or lack of it?
Yes, there is no serial number, that's admitted.
What does that mean?
If I had time, I would take instructions. But if you go to the next column, my lord,
Yes.
it says it is signed by two agents, ODM and Jubilee. So that the next question, my lord, why were the agents of ODM and Jubilee signing the form for Nyali? So they are signed. Is it reasonable to expect a party who has signed a form to come here and disown the form?
Macharia,
Yes, Your Ladyship.
you're making the assumption that the voter votes for whatever candidate it is they want.
Yes,
And when putting, and that's an assumption,
yes,
when putting their ballot box in their ballot papers in the box
yes,
for the candidate they have voted for,
yes.
they would put all 6.
No.
That's the only way
Yes,
a stray ballot would arise. A stray ballot is one
yes,
which is put in the wrong box.
correct.
So even though it is correctly marked,
Yes.
it is dropped in the wrong box.
Correct.
My question is this:
Yes,
where a candidate, where a voter collects the 6 ballots,
yes,
because the assumption is we will be given all 6,
yes, you're given all 6.
and you want to vote for only one candidate.
Yes.
Where do the other 5 ballot papers go? It's a very simple question.
That's what I answered, Your Ladyship. That the law, and I think the regulations actually make it quite clear that even having been given 6, and even with the color coding that the ballot boxes have and the ballots themselves have, room is still created for what Your Ladyship correctly called the stray ballot, which is a correct ballot placed in the wrong box. Now, when you look at the regulations and you decide to do your ruling, you will find that those stray ballots are kept in a separate envelope by themselves according to the rules. Yes.
Mr. Macharia,
Yes, my lord.
you are still not answering the question.
Yes.
You walk into a polling booth.
Yes.
You're given 6 ballot papers.
Yes.
So you decide, as you may decide,
Yes.
that you'll only vote for a presidential candidate.
Correct.
That leaves you with 5.
Yes.
Those 5
Yes.
are not stray.
And
No.
this is today.
Used.
Yes.
You've been given 6,
Yes.
but you have elected to use only 1.
Yes.
That leaves you with 5.
Yes.
What we are asking,
Yes.
where do those 5 go? How are they?
Why?
They're not stray.
No, they're not straight.
They can only be stray if they have found the wrong ballot box.
And that's the point.
So they're not. So you still remain with 5.
Yes.
Where do you put them? You carry them away?
No, 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 no.
How are they counted for?
No, and that's the point I'm making. You vote. Vote for 1. Vote for the 2nd. Vote for the 3rd. You have 6.
And this man still, when he now said that he and his wife later reconciled.
Please cut me around. These things you said that were cast on the television screens.
Yes.
What did you call them?
They have been referred to in my client's responses as statistics. In my submissions, I refer to them as data. But my lord, what I want you to carry away from my submission is that those figures were not the result and they did not form the result.
What were they?
My lords, I have explained that prior to the decision, and the phrase I used was surgery. prior to the surgery that was carried out by the Court of Appeal on section 39, 2 and 3 of the Elections Act, those figures were what were referred to as provisional results. What used to happen with provisional results is that they were sent electronically as text messages. And my client would then transmit, or the presiding officers the presiding officers would then transmit either electronically or in hard copy. They would transmit the physical Form 34A to the National Tally Center. And the National Tally Center would then confirm, once they received the physical Form 34A, that the results that had been received electronically.
Let's go to the polling station.
Yes.
You completed Form 34A.
Yes, ma'am.
You scanned it.
Yes.
The figures on Form 34A, you now manually enter them.
Yes.
Into the what?
Into the KIMS kit.
Yes.
Yes, ma'am.
What do you do with them?
You send them simultaneously.
Yeah.
Send them simultaneously to the National Tally Center and to the Constituency Tally Center.
Yeah.
And then at the Constituency Tally Center, the first collection of the results is done. And the first collection is then sent as Form 34B to the National Tally Center. At the National Tally Center, the Form 34Bs are tallied from the 291 constituencies and a result declared.
So the ones which are entered manually are the ones which went to the screens?
The ones which were entered manually, my lord, are the ones which went to the screens. Yes.
Okay.
But they were not the result, and they were not the result because of the decision of the Court of Appeal, Civil Appeal number 105 of 2017. They were provisional results.
Let's just stop it there. That is the IEBC lawyer saying that the results that were projected at the National Tallying Center were not results. And then one of the things that emerged also was that the difference, the presidential votes in Kenya generated 1 million votes. In other words, 1 million voters voted for the president and did not vote for other 5 elective offices. So the judges were asking, where did these results come from? And this demonstrates the approach, especially on the substantial effect rule, scrutiny, burden of proof, and you saw how the burden shifted, as well as on the question of the standard of proof. I thank you, and my apologies for taking long.
Another round of applause for Felix. But the question remains, what happens to the other 5 ballots? I'm still wondering, what happens to the other 5 ballot papers? Maybe we'll engage during lunch and find out what happens to the other 5 ballot papers. I believe that the presentation is now ready, and I call upon Justice Maria Kawimbe to come and make a presentation. Okay.
Good morning, my lords, the Chief Justices, my lords and ladies of the Superior Courts, the honorable magistrates and invited guests. My presentation is on drafting clear and simple judgments in elections to be understood by citizens. So this is quite an unusual presentation because it is not focusing on what would contain a good judgment, but rather looking at the principles of the rule of law, easy access to justice, and looking at the educational value that judgments bring. In the course of my judicial career, just like any other judge in this room, we've always struggled to wonder whether our judgments are understood, in the sense that mostly you'd find that judgments are usually written for legal practitioners or those who have knowledge in law or some basic understanding. They could be in academia or the students themselves, but never for the general public. So my role is really to focus on the reasons why simplicity and clarity are desirable in judgment writing. A useful starting point is, as I've stated there, that a judgment will communicate the final decision made by a court. And in most cases, even on some of the judgments that go on appeal and are delivered by superior courts, the lower courts would not even understand what was contained in that judgment. And if the courts or judges themselves do not understand, or magistrates do not understand the decisions that have been made or the jurisprudence emerging in those judgments, then it even becomes more difficult for a common person. Here, there, I give what the parameters are on writing a judgment, and that the intention is to resolve a dispute between parties and establish their rights and obligations in the most clear and simplest terms. This is an area which is now emerging. It is a very difficult area for judges, because now the public trust and scrutiny and confidence in the judiciary is no longer being looked on courts as a revered body. There's a lot of critique about opinions and judgments of judges, and it has been it can be very negative, especially in social media. Social media is a very broad coverage, and I am one of those, especially after a judgment has been written or delivered by me, that I would go to social media, because then I can gauge whether people understood my judgment or not. I know judges don't like going to social media, but it's an area where I encourage people to really engage, because then you'll get the real feedback in terms of the decision that has been delivered by court, whether it has been understood or not. If you do not do that and maybe even try to improve, because in Zambia we have had quite a number of cases, and especially those to do with elections, where the judgments of the court were not understood. And this fueled a lot of disinformation or misinformation, which is a threat multiplier to the independence of the judiciary. Negative perception also, depending on the audience, even attacks the judge. Because yesterday we saw those pictures from Nigeria on some of the judges. And when you look at it at face value, you would have thought this judge is sitting with two young girls, and yet they were his grandchildren. So if we are not careful, and if I know we stand at number 4 in terms of public trust and confidence according to the Afrobarometer, but if we are not careful, we lose in integrity before the electorate and those that view us and those that receive our service, especially during elections, that is the political players. This again on public confidence, and really to say that as much as perception against courts can be negative, our judgments provide us an opportunity. We should use those negative criticisms through our judgments, especially when we have cases which we are dealing and which involve high stakes issues, to set up issues of public law in public interest and create more understanding among members of the public about our decisions. Our work, ladies and gentlemen, my lords and ladies, is about public trust and confidence. So if we are not clear in our judgments, or if we are not understood, we will continue to be a source of attack in the work that we do. Constitutional duty to write judgments, but it's very important that we understood. I now come to the benefits of drafting clear and simple judgments. And first among these is clarity and avoiding ambiguity. In election petitions, as I say there on the slide, the audience to be persuaded is significantly broader than the typical lawyers writing for lawyers. This is very important in elections, as I said, which are highly charged affairs, and the audience is expectant. It's more painful for the loser in an election petition to receive a judgment. And because of that, clarity and avoiding ambiguity become good tools for communicating our judgments in order to increase understanding among the public while exposing principles on the rule of law and other laws that regulate electoral conduct and participation. So I have taken liberty to get some cases that are not directly connected to electoral decisions, but just to show you that in certain of these judgments, the courts here express themselves with great clarity. If you look at this case, it is a case of the Supreme Court of Seychelles, and it's very nice because there you see the court telling you what the issue in the case is. If you allow me just to look at the first sentence and maybe read it aloud, it says, soon after the declaration of results of the 2015 presidential election, the appellant, the presidential candidate who obtained the next vote after the elected president, had brought an action against 3 respondents. The case goes on to tell you what is involved. I just got a small excerpt, but later on it really involves and exposes the issues that the court had to deal with. Another case which I think is very instructive on clarity and ambiguity was written by the Honorable Chief Justice of Zambia when he was a Supreme Court judge in the case of Matthew Shishimba Nkata versus Dolly Mwenda Kata. This case concerned a matrimonial dispute. But if you look at the language that was employed there and how he set out the case, it was very clear and easy to follow from the outset what the case was all about. Even if it's about a love story and the peril of love, it's that simplicity and clarity with which the case was reviewed. And this is something that can be adopted in when judges are dealing with election petitions. More importantly, this Kata case has become a regional authority, in fact, a great authority on the sharing of matrimonial property, because there's been some debate and it's been quite contested whether this reference to the 50-50 dogma is what should guide matrimonial causes or separation. But in this case, what the Supreme Court said, and through the Honorable Chief Justice, is that the sharing of matrimonial property should not reside in a fixed formula in law. It should not be a matter of mathematics, as simply in splitting a piece of land into 2 equal portions. Equal rights between husbands and wives do not necessarily translate in every case into equal portions of family property. Each case should be determined in terms of how much each party contributed and an appropriate percentage of the matrimonial property apportioned on that basis. Moving on to the, okay, this is the Nkata case. Okay. I'm sorry. Oh, yes. I'm sorry, Dr. Matlosa is the one who gave me a tutorial so on how to operate this gadget.
Okay.
Yes. Okay. Some training too. Yes. The next issue, why our judgments need to be clear, especially in election-related cases, is that when they are clear, they increase public accessibility to court proceedings. Difficult legal proceeding principles are simplified, leading to a clear understanding of how courts decide cases. On building public confidence and trust, which again, as I said, is a very important area, clear and simple judgments can build trust among citizens. And in election cases where losers understand the judgments, they will be more likely to accept the legitimacy of election results. A case demonstrating the independence of judiciary amid this fierce negative perception interfering with the confidence and trust of individuals in the institution is a case of President of the Republic of South Africa and others versus the South African Rugby Football Union and others. Even if it's not an election-related case, it demonstrated on the principle of judicial independence and authority that the court must, in all cases, move to make sure that it protects its integrity. And how does it do this? Through its decisions, which must be clear and simple. This is a very famous case, which I'm sure your lordships and ladies are very well aware of. But in that case, maybe just to put in a little bit of perspective, the Constitutional Court of South Africa was the integrity and the reputation and the conduct and the abilities of the judicial officers, that is the Constitutional Court of South Africa, who sat in that case. Their reputation was brought into into question. And the court clarified that on the rights that litigants possess, that they can object to their cases being heard by particular judicial officers. More profoundly, the court pronounced itself on the principle of the right to raise objections, that it should not be exercised wishfully because judicial officers owe their fidelity to the law and in most cases exercise their authority appropriately. The Supreme Court further went on to develop other principles which are stated and will be shared through my presentation. On the element of judgments being an education tool, we seem to have underestimated the importance of judgments being educational tools, more particularly because when we write judgments, for some of us, we are looking at the issue of saying that we have completed our task, we have exercised, rather we have satisfied the public expectation in that the judgments have been timely delivered. But judgments do actually serve as a good educational tool. And one of the cases that I really like and demonstrating this point is the Zimbabwean case of Inrimu, Henesu, and others, where the Supreme Court of Zimbabwe addressed the issue of limitation of constitutional rights in a democratic society. And in this case in particular, they dealt with the freedoms of assembly and association, intrinsically linking them and also saying that without freedom of association, the right of freedom of speech is associated with the right to freedom of assembly. It's a very good case, and I encourage my lords and ladies to read it. Clear and simple judgments also act as legal precedents. On legal precedents, they contribute to the development of consistent legal precedent. When legal reasoning is transparent, it establishes a foundation for deciding future cases. And this is aptly represented in the case of the Raila Amolo Odinga versus Independent Electoral Boundaries Commission and two others. Everybody knows this case. The previous speaker spoke about this case, but it's very instructive on setting legal precedents and also guiding lower courts and other courts where the law is not substantial on how an election petition, presidential petition at least, should be assessed and determined. In terms of media and public discourse, and I'm coming to the end of my presentation, clear and simple judgments are a very good tool in helping journalists to accurately report the court judgments and thereby eliminate the possibility of misunderstanding in storytelling. On judicial legitimacy, the perception of the judiciary's credibility is enhanced by the quality of judgments delivered by courts. When they are well articulated, the public is likely to find it easier to understand them and to accept them. In concluding, ladies and gentlemen, my lords and my ladies, clear and simple writing of judgments is profound. It influences civic and public engagement, as well as institutional trust between the judiciary and the people. It should not be seen as a matter of style that now that adjudicators can develop, but a basic requirement that courts should seriously consider when communicating their findings and decisions to parties. Finally, a judiciary that affirms its dedication to justice, accountability, and democratic values can only do so when it communicates in language that is understood by a great majority of individuals or citizens. After all, a thriving democracy depends on an informed and engaged population as opposed to passive onlookers. I thank you.
We are fast running out of time, and the next presentation is going to be a virtual one from Dan Dare, if he is available. And if he can hear me, Dan Dare is the Executive Director of the Pan-African Lawyers Union. Dan Dare, you've got 10 minutes to make your presentation. If you can hear me, please take it off.
Thank you very much, my lady. I'm privileged to be before all of you, my ladies and lords, justices from our eminent courts across Eastern and Southern Africa. I start by apologizing that due to factors beyond my control, extended family issues, we are Africans, I was not able to be with you in person much as I would have liked to. Also, in the interest of time, I stand on the established protocol so we can move ahead. I would like to start by endorsing the clarion call that was made yesterday by the Honorable Mr. Justice Isaac Lenaola, who called that all judiciaries on the continent should strive to use the same standards in electoral dispute resolution, of course, as in other areas of the law. And just a few minutes ago, when my colleague, Felix Owura Advocate, was elucidating the evolution of jurisprudence on electoral matters across the continent, I think it really stuck to me that we should all strive for a high standard and that we should all stick to it. In that way also, there comes some safety in numbers, in that we will not be castigating some judiciaries while praising others. And at the same time, even those that deigned to intimidate judiciaries will find it harder to do so when we've all taken the same high standard. And my ladies, my lords, I put it to you that one of the greatest duties that African international courts and tribunals can do for the continent, for its peoples, and especially for national judiciaries, is to make strong regional and continental jurisprudence and give detailed directives that thereafter all national actors, including all national judiciaries, have no option but to implement within each of the 55 countries in the 5 regions of continental Africa, the diaspora, of course, being our 6th region. And I prefer to use the term African international courts and tribunals because in positive international law, there's really no hierarchy of norms. So we have sub-regional norms. The norms at the level of the regional economic communities, such as SADC, the Southern African Development Community, ECOWAS, the Economic Community of West African States, the East African Community, and others. So we have norms at that level. And of course, we have norms at the continental level, essentially the norms of the African Union. And again, in terms of courts, we have courts and tribunals at the continental level, such as the African Court on Human and People's Rights, based here in Arusha in Tanzania, or the African Commission on Human and People's Rights, based in Banjul, the Gambia. But we also have sub-regional courts and tribunals, such as the East African Court of Justice, the Community Court of Justice of the Economic Community of West African States, the ECOWAS Court as we call it, the Court of Justice of the Central African Economic and Monetary Union, the SEMA Court, and the SADC Tribunal, although, of course, for the moment, the SADC Tribunal is limited to being an interstate court and has no access for citizens. So my ladies, my lords, why do I say that African international courts and tribunals can help strengthen, especially in the context of electoral jurisprudence and electoral adjudication, but in other fields as well, what happens at the national level, which is the most important level? There are a number of reasons. One, the regional continental court lends regional legitimacy. As the judges that sit on it come from the different countries in the region, it addresses the perception that sometimes occurs with national judiciaries that the bench is partisan. Here, the judge doesn't just come from the country in question, if he or she does, but from the neighboring countries or the countries across the continent. And many times the lawyers also come from across the region and the litigants too. Two, The international courts and tribunals in Africa lend themselves to comprehensive elucidation of the law. This is because a court or tribunal is able to apply the totality of the regional or continental laws, policies, regulations, and standards on elections, such as the ones Professor Kabele Matlosa was reading to us in the morning, but it also applies the applicable national laws, regulations, policies, and standards. So it's more comprehensive. 3, it can help us set standards. Because if a strong regional standard is set, then despite the plurality of legal systems that can occur across the region, there'll be certain standards, laws, and principles that should be applicable to each of the countries. And in this, it gives a harmonizing effect because it helps to bring into harmony all the national courts of the region and all the national laws of the region so that they subsequently apply the same high standards so that we all progressively adopt and implement high standards. 5, it lends itself to regional solidarity. In the true spirit of Pan-Africanism, it means that individuals and institutions, including institutions from sister states, can help to speak for their counterparts in country X when their counterparts are not able to speak for themselves. Or even when they're able to speak for themselves, you can join them in solidarity. So in our personal experience as PALU, we have witnessed instances where a country has gone through elections in very controversial circumstances, and the level of suppression of civic space is so high that citizens and activists in that country are afraid to challenge at the national level or at the regional level the electoral exercise. But because, for instance, in the context of the East African community, any citizen or institution resident anywhere in the community can lodge a complaint regarding anything that happened in the community. We've had situations where CSOs from the sister state are the one that filed the case on behalf of citizens from state X who are not able to file at the same time. This is no better demonstration of the principle of moving from non-interference to non-indifference to what happens to our sisters and brothers in neighboring states. The regional courts also have an insulating effect in the sense that even if they're now adjudicating on something that happened in country X, at the regional court, the judges and the staff come from multiple countries. Therefore, they cannot be easily intimidated or castigated or corrupted. But also at the national level, which for me is the most important, the regional court is able to say things that can then insulate the national level judges and enable them subsequently to make tough decisions because after all, they can say we have no option but to follow the regional standard that has been set. So in a sense, we insulate the national judges when they want to make tough decisions. They cannot be accused of, having done something wild. It is because this is a standard that has been imposed on them by decisions affecting them that have been made by the regional continental court. But also, the international courts afford some measure of transitional justice. 1, documentation, truth-telling, and memorialization. It enables us to accurately document for posterity what happened in a particular election or electoral cycle, even if we cannot change that history. And this is especially important when we cannot change that history. Something has happened in a country, we feel violated, we are not able to do anything with it. We'll have to live with the result for the next 5 years at least, but at least let's somewhere have documented the truth of what happened. It enables some measures of guarantees of non-repetition in that the international court, when making its decision, even if it's after the fact, it is able to order structural reforms. It is able to order what we call transitional justice reforms. And because it's operating at a regional level within a REC or the continent, it enables other institutions and organs of that REC or of the continent to act. So for instance, the African Court on Human and People's Rights can issue a decision in respect of country X and say, you have to amend your constitution this way, you have to amend your laws this way. Then other organs and institutions of the AU, such as the African Governance Architecture, the African Peer Review Mechanism, the Pan-African Parliament, and others can help the state to implement those decisions. So after laying that basis for why I feel that it is important in our scheme of things, in our progressive realization of democracy, good governance, rule of law, human and people's rights in the continent, to have regional and continental courts, let's look at some of what they've done. And time being of the essence, I'll look at it in summary. So our courts, both at the continental and regional level, have been very active in electoral dispute resolution over the last decade, precisely because the citizens have asked it, the democracy and human rights activists have asked it, and in some instances, politicians have been active. It is always worth reminding the public, especially when we're condemning courts, that courts don't file cases. Indeed, courts don't even frame cases. It is the litigants and lawyers that do. Courts often have to deal with the case as it is filed, for better or for worse. So we do not blame courts for the existence of litigation, and we do not blame courts for cases that could have been conceptualized better, drafted better, filed better, or even argued better. So as has been pointed out in the concept note, PALU, the Continental Body for Lawyers and Lawyers Associations, successfully procured 3 years ago an advisory opinion from the African Court on Human and People's Rights on the rights of citizens to participate actively and effectively in their governance, even in the midst of a global pandemic. We filed the request on 3rd June 2020, and even though it was COVID time, the court strived itself, and in a year later, on 16th July 2021, it delivered its advisory opinion. The opinion identifies and addresses 3 combined questions. 1, on the decision whether to conduct or not elections during a public health emergency or a pandemic, such as the COVID-19. 2, on the obligations of state parties to ensure effective protection of the citizens' rights to participate in government in their country in the context of an election held during a public health emergency or a pandemic. And 3, on the obligation of states that decide to postpone. So on 1, what are your obligations if you decide to hold the elections? And 2, what are your obligations if you decide to postpone the elections in the context of a public health emergency? And in summary, it said many things. The court first reaffirmed that elections must be regularly held on the scheduled timeframe as provided for by the African Charter on Human and People's Rights, and also the African Charter on Democracy, Elections, and Governance. But then it said, in the context of a public health emergency or pandemic, decisions must be demonstrably science-based and evidence-based. 3, that there must be wide consultations between the 3 arms of government and other stakeholders, such as political parties, civil society, faith-based movements, and so on. So a decision whether or not to go ahead will be a collective decision in the country, and not the decision of one set of actors only. Then they say that state parties that decide to go ahead to conduct elections.
See me 1 minute to wind up, and I'm going to stand here until you wind up.
All right. Okay. Those decisions must be consultative, must be science-based, and must not undermine the rights of the people. There are also a whole series of adjudicated cases from the African Court, African Commission, ECOWAS Court, East African Court of Justice that address several issues in the electoral process, and that is where I'll end, because this is what has already been done. They have expressed themselves clearly and authoritatively on constitutional or legal systems that do not allow independent candidates, constitutional or legal systems that do not allow certain electoral result declarations to be challenged in national courts, especially presidential election results. They have expressed themselves on the composition of electoral management bodies, especially when these are not well composed, on the unlawful refusal of certain candidates to contest certain elections, that is locking out candidates, on the third term phenomenon afflicting incumbent presidents in Africa, on violations of principles of national consensus, And they have also been able to revisit orders and decisions of national courts and tribunals on elections when these are worthy of being challenged on one ground or the other, especially due process.
And
so my
in
final
conclusion-
call,
in
it is
conclusion-
important for national actors
Mr.
and in
Daya?
this particular national judiciaries to do two things. One,
Mr. Daya,
yes.
in conclusion,
Yes, in conclusion,
Yes.
it is important for national actors, especially national judiciaries, to do two things. One, ensure that they play their part in ensuring that we send the best possible women and men to be judges in these regional and continental courts and tribunals. And then two, to ensure that when decisions are made, they respect them, implement them, use them, and apply them at the national level. And in so doing, we strengthen the entire system. In protecting the regional courts, we are protecting ourselves as national actors. I thank you.
Thank you very much. We don't have much time for plenary, but I will allow at least 3 questions from the floor, if there are any. Emphasis on if there are any. Three questions. I think that's Advocate Takula right at the back. That's one. Any other hand up? Then there's another hand there. Microphone, please. Second one. The third hand. Is there a third hand coming up? Going once? Guys, not. So 2 questions. Oh, there is a hand. My eyesight fails me. Yes, the gentleman in the back, third hand. Shall we have the 3 questions quickly for our panelists and presenters?
Thank you very much. Justice, let me also thank the panelists. I have a comment actually, not a question. Dr. Matlosa, thank you for your presentation. The African Commission on Human and
Sorry, please introduce yourself. Please.
Sorry. Can you hear me? Yes, my name is Pensi Tlakula. I'm from South Africa. I have 2 comments. Dr. Matlosa, the African Commission on Human and People's Rights in 2017 adopted a guideline on access to information and elections. It's the first standard-setting documents on elections and access to information. And that document stipulates what information must be made proactively available by which stakeholders during an election. It deals with political parties, EMBs, the media, election observers, and so on. So what it does, it says that it's not only EMBs that have to be transparent. Everybody has to be transparent, including the media. So it will be important, I think, for participants to look at that document because it is very interesting. When it comes to disinformation and misinformation, I think we leave social media platforms out of the loop because we can only deal with misinformation and disinformation if social media platforms are also required to be transparent, so that we can then ask them what policies do they put in place, how to deal with disinformation and misinformation, how much money do they allocate to deal with, can they make their data available to researchers so that researchers can also use that information to look at how they deal with disinformation and misinformation. So what I'm saying is that we need to begin to ask for transparency from social media platforms so as to hold them accountable. Thank you.
My name is Elita Pirimwekisa from the High Court of Zambia in Lusaka. I would like to thank the panelists for well-presented papers. My question is specifically directed to Felix. I hope I've got the name correct. He did mention that the standard of proof in election petitions is higher than mere balance of probabilities. Now I'd like to find out, yesterday, Justice Leonola mentioned that in the Odinga case, they had to shift that standard of proof to the respondent. I don't know if it was in the Odinga case, but I would like to find out at what stage of the petition does the standard of proof, does the court decide to shift the standard of the burden of proof from the petitioner to the respondent, and what would precipitate such a move by the court? And more so that the petitioner is the one who's making serious allegations of electoral breaches against the respondent. And once that the burden of proof shifts to the respondent, I would assume that the respondent will also have to prove his or her case to the same standard of a higher degree of probability. So I just need your comment on that one. Thank you very much.
Thank you. My name is Bukola Idowu from Federal Republic of Nigeria. I have a question for the Honorable Justice from Kenya. And my question is, when we can the judiciary also play a key role in legislation? And I'm asking this because, for instance, in Nigeria, the politicians, the legislative arm make the law, and then the general assumption is that the judiciary is just meant to interpret the law. And in a situation where the legislative house, the majority in the legislative house are from the main political party. So most times we've seen laws made in order to tackle the opposition and make sure that the opposition doesn't even win at the election. So we've seen, for instance, our Electoral Act of 2022 was basically to favor the ruling party. For instance, when you talk about this substantial, you have to prove the case substantially. Nigeria has 176,000 polling units, 93 million registered voters. Now, how do you call witnesses in most and to be able to prove substantially? So this is absolutely difficult, and the court has agreed that this is absolutely difficult. For instance, the PDP, Atiku and Obi, decided to call like 7,000 witnesses, and the court said, look, where do we have the time to call 7,000 witnesses? So they have to slash that. But at the end of the day, the judgment reads, not substantially, you cannot, they've not been able to prove substantially. So the politicians have made they are so mischievous in drafting some of this law, and the judiciary at some point want to take it and run with it and say, look, it's justice according to the law. So at what point, because it's putting the judiciary in a difficult position, and at the end of the day, they are at the receiving end from social media and every end. So do the judiciary have a role to play in some instances to formulate some of these laws? Thank you.
Before the panelists respond to that, we've got a question from a virtual participant. Monica, if you can hear me, please proceed with your question.
My lords, heads of courts, and the other participants, it is instructive that I'm speaking directly after somebody who has said something about.
Monica?
Yes.
Yes, please proceed with your question.
Yes, I can proceed with my question. I wanted to make a little contribution to say that maybe issues in election contests should be streamlined. If we streamline, issues, it might be easier and more transparent for the courts to be able to address them. And the issue of burden, election, unless we're trying to move away from the concept that election is sui generis and should be given special procedural rules and regulations, we cannot meet up with the constitutional requirements of election, choosing our leaders by process of election, and determining electoral disputes tenuously to allow the elected persons to proceed and address their avowed commitments to the citizens of their nations. I agree that there is a need for the African continent to come together with some basic principles that should guide electoral adjudication. And the transparency, I think, we've taken steps. It might not be universal, but for instance, in the court, since I'm the president of the Court of Appeal, and we are responsible for electoral adjudication. We try as much as possible, as soon as judgments are delivered, we put them on our website. Yesterday, I had someone complaining that those facts are not available. That is not correct. They are there on our website. And now we're talking of this other lady who spoke about writing judgment, the simplicity of writing judgment. I agree entirely, because when we are writing our judgment, it should be for the public, not for the lawyers or lecturers. Those who want to define terms should go to the universities. And in our presidential election, and in fact, the current proceeding, adjudication in our current electoral process, we tried as much as possible to be as plain in our language as possible. So
Monica,
that should help. Yes.
Can you hear me, Monica? Please frame your question, one question that you want to put to the panelists. We are running out of time. Frame a question for the panelists in addition to the made.
I've stated my opinion. I don't have any question, just to contribute to the general discussion.
Yes, we appreciate that, but we are running out of time, and this is question.
I'm done. Thank you very much. I'm done.
Thank you. Over to you, panelists, if we may start with you.
Thank you, Justice. Let me thank all the distinguished participants for the inputs. There was no direct question to me. There were two comments by Advocate Pensi Dlakula that I endorse. And it would be good if they also feature in our outcome statement, because they're very important. One is about access to information guidelines by the African Commission on Human and People's Rights. I remember this very well. And the other is on social media regulation. I think those are important issues to incorporate in our outcome document. Let me add on the social media. something that we have not yet spoken about, or I didn't mention in my presentation, is that there is, and this is about ensuring transparency and accountability of the media during elections. There is the Association of African Electoral Authorities, AEJN, which is based in Ghana, adopted recently an important document that I think we should also highlight in our outcome statement. The document is Principles and Guidelines on Regulation of Digital and Social Media. I think we should also capture that because it's very important. It was adopted last year in December, actually, in Cotonou, Benin. So it's a very important tool for EMBs as well as the judiciary in trying to find ways of how to regulate the social media, digital and social media. That's all, Justice, that I wanted to say.
Thank you very much. For the question from my Nigerian brother, sorry, I didn't get the name very clearly, but you posed a good question whether the judiciary can play a role in legislation. Obviously, we know that the legislative role in any country can only be exercised by the legislature or parliament. And what we have done as Judiciary Committee on Elections in the context of the issues I was discussing is that after an election cycle, we engage the relevant stakeholders. I mentioned the the Justice and Legal Affairs Committee of the Parliament, for example. The electoral body, in Kenya we call it the IEBC, stakeholders like advocates look at the legislative gaps that exist and then propose certain amendments. We go call those members of parliament who form that committee and all these other stakeholders and take them through issues that have been raised by various courts. For example, the Supreme Court, which is the final court in the land, may make a certain recommendation or say that there is a gap that needs to be addressed. We isolate, we identify all those areas, and then we persuade Parliament to amend the laws accordingly. There was, for example, a confusion as to whether election petitions should be filed within 28 days of declaration of results or publication of results. And the Supreme Court made it clear because some people were waiting until the results were gazetted. The Supreme Court handed down a decision and say that time begins to run from the date election results are declared. And so there was need to go and have the law amended accordingly. So we engage those various players in amending the law. Even in areas like limiting rights of appeal, because we had a scenario where disputes from nomination disputes would go all the way from PPDT to the Supreme Court. And we say, no, there ought to be a limit. But to achieve that limit, we had to engage Parliament and say, this is the reason why we need to limit the right of appeal. And so by persuading the Parliament, legislature, that it is in the interest of all parties concerned, including themselves, to do various things. We've been able to get these amendments done. We know that towards elections, it's very difficult to have the law, particularly regarding election, changed. So what we do, we engage them immediately after we've done the debriefs. And that will be the right time to have the various gaps that have been identified filled by the legislature. I don't know whether I've answered your question. Thank you.
Thank you very much. Very quickly, the question posed by the Honorable Judge from Zambia. Let me say the following. One, with respect to the standard of proof, and yes, the Honorable Justice Lenaola spoke about a higher standard, which the Supreme Court of Kenya has framed as an intermediate standard. This jurisprudence is relied heavily by Kenya, Zambia, and Uganda. To the best of my knowledge, it is only these three countries that have adopted a higher standard in the determination of which is the intermediate standard in the determination of electoral disputes. Now, majority of the courts in Africa are firmly aligned with the jurisprudence from the Malawi Supreme Court, and this includes Zimbabwe, Ghana, and a host of other countries that have properly argued and reasoned that there is no point of burdening a petitioner with a higher standard, and that the appropriate standard of proof in election petition has to be the civil standard, which is on the balance of probabilities. Now, at what point does the burden of proof shift? In Kenya and Malawi that have adopted a disjunctive interpretation that a petitioner needs to prove that there were substantial illegalities and irregularities, and that elections did not comply or were not held substantially in accordance with the law, and they so-called affect the results. The two courts have applied a disjunctive reading that a petitioner need, or you don't, once you can prove that there were substantial illegalities and irregularities, the results are irrelevant. Now, so the first onus, the initial burden is on the petitioner to discharge that initial burden to the satisfaction of the court, that there were irregularities and illegalities that were committed in that election. Now, once that burden is shifted, Kenya and Malawi have reasoned that the best evidence in an election petition is in the hands of the Electoral Commission. They are the custodians of ballot boxes, ballot papers, statutory declaration forms, and things like that. That therefore, the burden must therefore shift on the respondents, including more so the Electoral Commission, to demonstrate and issue the necessary rebuttals that the election was held substantially in compliance with the law. Now, if you saw the video clip in Kenya, the Electoral Commission repeatedly and routinely failed to satisfy and discharge the necessary rebuttals that were expected. Thank you very much.
That response by Felix marks the end of this session. Can you kindly give a round of applause for the resource person and panelists? For a jam-packed session, I'd call it a jam-packed session, and I must protest on their behalf that they were not given adequate time. They needed more time, and I also needed more time. But I did not manipulate the program to extend my tenure. I close this session and hand over to the events director. Over to you, Arnold.
Thank you very much, Justice Makarao. And I also apologize to you. It's very clear that the resource persons were not given enough time. You were not given enough time. And the session was overloaded. They had a lot of information that we all needed. And it will inform our future designs of programs so that there is enough time. What it means is that we've also overrun into the time for the next session, and there's an electronic online presenter, Ambassador Salah, who was already telling me that his internet is not very stable. So I don't know, maybe the shortest possible time for a break. A healthy break is also important for people just to freshen up. So can we do 10 minutes at most, which is coming back here at, maybe 10 to 12, Yeah, 10 to 12. That will give us at least 14 minutes. And hopefully we'll be able to accelerate in the next session. So in that, let's take the 10 minutes break. We stand and our Chief Justices leave, and then we can follow them. Thank you. There's another announcement. I'm very sorry. I think it has to do with itinerary. There's a list circulating about itineraries so that people can confirm, reconfirm when you're going away to help the JSC logistical staff to give all of us support and make our exit smooth. So please fill that itinerary. Thank you. May we stand? Well done.
Kamara na to ne la. Oh. Halo wani di model na.
Di model na. Aku ni deh.
Ana normal.
Yeah, ayo ikuzwa ndinendiro okay. Docho authority tiri kuwekyo.
Yes.
Yeah, and giving a presentation on the rule of law. Thank you.
Bagaimana Pak dalam konferensi? Sentro.
Shall we stand as the Chief Justices enter? Yes. Thank you very much. The next session is going to be led and moderated by Justice Paddington Garwe of the Constitutional Court of Zimbabwe. Justice Garwe, if you may be able to take your seat at the front and organize your team of your panel. Justice Garwe is a judge in the Constitutional Court of Zimbabwe, very experienced, from the time I graduated the university. I think you were already somewhere in our apex courts, in our superior courts in the 89, 90s. So he's really a depositor of wisdom. I remember when I was at the university and just joining the legal profession. That's where the concept of alternative sentencing was happening. And you were a global leader on alternative forms of punishment in order to deal with decongestion in our courts. So it's really something that I know off the cuff. And your bio is inside the program, and people can read it for themselves. So I hand it over to you, Judge.
Thank you, Director of Ceremonies, Mr. Arnold Tsunga. The chairperson of AEJN, Honorable Justice Mba, our Chief Justice, the Honorable Luke Malaba, the Honorable Chief Justice of Eswatini, the Honorable Chief Justice of Zambia, the former Chief Justice of Kenya, Chief Justice Emeritus Maraga, other distinguished guests, justices. I write on the protocol that has already been established. I appreciate that we are behind time, so I will try to be as precise as I can be. I consider it an honor, a privilege to have been asked to chair this particular session, which once again focuses on the African Charter on democracy, elections, and good governance as a tool for entrenching universal values and principles of democracy, good governance, and human rights in electoral justice. More specifically, this session interrogates Chapter 9 of the Charter, dealing with political, economic, and social governance, which in Article 29 recognizes the crucial role of women in development and strengthening democracy. That article further urges state parties to create an enabling environment for the full and active participation of women in the decision-making processes at all levels, and to take all possible measures to encourage the full and active participation of women in the electoral process in order to ensure gender parity and equality. The article further urges state parties to promote the participation of social groups with special needs in the governance process. Against this background, the session will address how the lack of representation has consequences in electoral disputes, during which the rights and interests of women and other marginalized groups may be overlooked. The keynote presentation will be made by Ambassador Ahmad, who, according to the program, has been given approximately 30 minutes, but I do not believe that we still have that kind of time. Ambassador Ahmad will make a virtual presentation. This will be followed by panel discussions by 3 eminent speakers. Sally Nube, who is the regional director of an organization called Equality Now Zimbabwe, which focuses on gender equality. The other panel discussions are Advocate Pansy Tlakula, who is the chairperson of the Information Regulator of South Africa. The regulator is a statutory body responsible for the right of access to information and data protection. She is also a member of the United Nations Committee on the Elimination of Racial Discrimination and a member of the SADC Electoral Advisory Council. She's a former chairperson of the African Commission on Human and People's Rights and is special rapporteur on freedom of expression and access to information. Her biography is not in the program of events that is before you. This second speaker is Miss Mary Pay da Silva, who is a lawyer, seasoned lawyer with a background in communications and media advocacy. She has more than 20 years experience in the legal profession, including law reform and policy advocacy and formulation. Has contributed to a legislative framework that is protective of women's rights in her own country, and at the continental level, as an expert on working groups under the African Commission on Human and People's Rights. She's a founding member of the Southern African Human Rights Defenders Network and has contributed toward the advancement of women's rights at the continental level through capacity building, advocacy, solidarity, and support for WHRDS, which I understand stands for Southern Africa Women's Human Rights Defenders Network. With strong networking skills and strategic and purposeful motivation, she has contributed to the establishment of formal and informal coalitions of women's and youth organizations. She has worked for the International Commission of Juries Africa program in defending the independence of judges and lawyers in Africa, and has participated in several high-level advocacy initiatives at the national, regional, and international levels. At this stage, I will call upon Pansy, Advocate Pansy Tlakula, to join me here, as well as Miss Mary Da Silva. If you can join me here. Thank you, Mr. Tsunga. At this stage, it is my pleasure and honor to call upon Ambassador Salah Hamad, who is the head of the African Governance Architecture at the AU Commission. Ambassador Hamad will be making or giving us a keynote presentation, but he'll be doing so virtually. I understand that he is online, and I now call upon him to make his keynote presentation. Ambassador Hamad, can you hear me? Ambassador Hamad? I think we are making progress. Can you hear me, Ambassador Hamad? I think we may have a problem with the sound. Oh, okay. Can you unmute your?
Thank you so much, my Lord. Moderator, I hope you hear me now.
Oh, okay. Thank you very much. We can hear you now.
Thank you so much, my Lord. I really appreciate it. And through you, my Lord, I wish to stand on the existing protocol, but I must recognize, my Lordship, the Chief Justice of Zimbabwe and all the Chief Justices that are with us this afternoon. And I wish to bring you greetings from the African Union Commission, particularly from the chairperson of the African Union Commission, and also from the Commissioner for Political Affairs, Peace and Security, and the entire family of the African Union. And I also wish to express my sincere apologies for not being able to be with you during or at this very important meeting. Ladies and gentlemen, I believe this meeting is timely and important because Africa this year, 2024, will be witnessing at least 15 elections at both levels, presidential and parliamentarian. So therefore, as we discuss the role of the judiciary in upholding the rule of law and ensuring free, fair, and credible elections in Africa, it's important that we also bring to the table the need for the publicity and popularization of our own African jurisprudence, and that is the African Charter on Democracy, Elections, and Governance, widely known as ACDEC. It is really important that to also note that, Excellencies, ladies and gentlemen, that the head of the team of the drafters who drafted this treaty is with us today. That is my former boss. And once you are a boss, you remain a boss for life. That is Dr. Herbert, or Professor, in fact, Habali Matlosa. And I hope he will be able to also supplement and complement my presentation. The presentation that I have put in a PowerPoint, but I hope it will not take the power away from me, is about the ACDEC, but also there is focus on youth and women participation in elections. I hope the host will enable me to share my presentation, if possible. I'm still trying to share my presentation, but I'm unable to do so. Excellencies, ladies and gentlemen, I hope now my presentation could be seen.
Sorry. Can you just repeat that again, Ambassador? I didn't get the last part of what you said.
Visible?
I think we may have a slight problem.
I'm experiencing, in fact, very difficult. Difficulties with my network here. We are outside of Addis today for a staff retreat, and maybe if I switch, I'm not sure if I switch my camera off, it might help. But in any case, Steve, is to request on my behalf if possible. That way we'll save time, and that way also we will have a better, of course, engagement since he's already there with you in the hall. But I can come back later to answer any question that might be raised. Dr. Matlosa, is it possible?
Ambassador Stella, this is Arnold. Yes. Are you able to share? The presentation is now on the screen. Are you able to show it? It's on the screen. Are you okay now to proceed with the presentation?
Oh, you can see the presentation on the screen.
Yeah, because you are now a co-host and you can share your screen and then speak at your own pace on the presentation.
Okay. Well, let me just use my presentation and speak without it if I cannot upload it because the network is very bad.
But do you prefer that we do it from here?
That would be great, in fact, if you could assist me from there.
But then, okay. the IT colleagues, are you able to share yeah, it's now on the screen. Maybe you can speak to it then, Ambassador. We are now sharing from this side. You can speak on the screen. We'll try to keep pace with your presentation. Thank you.
Thank you very much indeed. Excellencies, ladies and gentlemen, I wish to begin my presentation by a footnote that in a number of recent elections in Africa, we have witnessed a very successful story after members of the judiciary were quite involved in the electoral process. Without naming this country, Excellencies, ladies and gentlemen, we have seen members of the judiciary overseeing and also presiding over a number of pool and election stations in many African countries. And the participation of members of the judiciary increased the credibility of the election processes, but also attracted a bigger number of participants and citizens and voters to be part of the electoral processes. That is a clear evidence that the participation of the judiciary or members of the judiciary as supervisors and direct leaders of the processes at the national level can bring credibility to the process, to the electoral processes at the national level. Excellencies, ladies and gentlemen, we are all aware of the fact that 75%, if not more, or maybe around that number, of the African population of 1.2 billion are below the age of 35. That is a clear indicator that our African continent is a very youthful and young continent. And with our youth as the majority of the African population, it is quite important to also note that among the youth, the majority are female, women. And that is why it's quite important today during this presentation to highlight the importance of the participation of women and youth in the electoral cycle or the elections in Africa. My presentation will focus briefly on the origin and essence of the AGDEC, and I hope you are able to see the presentation. The AGDEC, as we all know, Your Excellency, ladies and gentlemen, is the African jurisprudence and contribution to the global governance affairs. And this charter is extremely important because the charter calls for an important platform and environment for the promotion of good governance, democracy, rule of law, constitutionalism at the national level. The charter also calls for a credible, fair and free elections, and it became, in fact, the legal
I think we have lost him. So maybe we could just proceed with and the PowerPoint and his paper he delivered in advance. What we could do with your permission, moderator, is just to share that with the participants later. But for now, I think for purpose of progress, we could just then proceed to the panel. Thank you.
Tunga? We clearly have a...
and that is why, Excellencies, ladies and gentlemen, our biggest problem, Excellency, and challenge is with the reporting process. Regrettably, from the 38 ratifying parties or ratifying member states, only 2 member states submitted reports so
The
far.
moderator, you can proceed.
Togo,
We've muted him. Then I'll send a message to him that we're going to distribute his paper. Thank you.
Our next speaker is Sally Ngube, the Regional Director of Equality Now. I hope that she's also online. Mr. Tunga, is she online?
She actually is online, but her preference was that she joins the panel.
Okay.
And so all the questions that you're going to be asking, she also participates in answering them as part of the panel online, rather than making an outright presentation. So she just sent a message now. So I think we can then just open up the panel and all those questions, and she'll be joining in as it goes, and she's following online.
Okay, all right. Yeah. Okay.
I'm so sorry, moderator. She's actually just sent a message to say she was kicked out. She's trying to rejoin. So I think we're getting straight into the panel, into the question and answer now. Yes.
What's going to happen is that we're going to do things a bit differently. The panelists, rather than make presentations, we have agreed that we would rather have a conversation during which there will be an exchange of views, discussions. We also ask Sally Ngube, and if it is possible, Ambassador Ahmad to chip in as and when necessary. Thank you. Well, so we find ourselves almost 20 years down the line after the adoption of the Charter on Democracy, Elections, and Governance, which I think we were advised yesterday was adopted in 2007. It's been hailed as a tool for the entrenchment of democracy, good governance, respect for human rights, the promotion of the participation of women in political life. Yes, it is. Can you hear me? Oh, okay. Maybe the distance. Hello, can you? That's better. Okay. So basically, what I was saying was that it's almost 2 decades after the adoption of the Charter by the African Union. And a number of questions do arise at this stage. How far have we gone in attaining the goals that were enunciated in that charter, as well as other sub-regional and regional human rights instruments, such as the 2003 AU protocol on the rights of women in Africa. I think that's generally referred to as the Maputo Protocol, and the 2008 SADC Protocol on Gender and Development. How far have we gone in attaining the goals enunciated in these instruments, in as far as the participation of women in political life is concerned? I also need to just mention that this particular session is primarily looking at the participation of women in political life, but I think the keynote speaker was also to speak on not just women, but also other vulnerable groups that are equally affected. Against that background, I will ask Advocate Satura to give us their views. Thank you, Advocate Satura.
Thank you very much, Honorable Justice Garwe. I stand on the protocol that you have recognized in the interest of time, because we have spent a lot of time, I think, trying to organize ourselves. So I recognize my Lord's Chief Justices and Honorable Judges here today and all the distinguished participants. On the continent, we are not short of human rights instruments. We have a plethora of them. Justice Gware has already pointed out to some of them. And in addition to that, I think we have Agenda 63 of the African Union that also has a paragraph on gender equality. Justice Gware has already in his introductory remarks talked about Article 29 of the Democracy Charter, which I'm not going to repeat. And we can look at Article 9 of the Maputo Protocol, which states that states shall take specific positive action to promote participative governance and the equal participation of women in the political life of their countries through affirmative action, enabling national legislation and other measures. Then you have the SADC Protocol on Gender and Development, which commits states parties to put in place measures to bring 50% representation of women in decision-making by 2015. How far have we come? The progress is very slow, actually. There has been, but it's very slow. There are very few countries that I'm aware of on the continent that have attained the 50% representation of women in the legislature. I don't even want to go into other areas such as the judiciary, such as companies that are listed on stock exchanges. Once we go there, the statistics become very depressing. I think the country that has taken the lead on this, according to the statistics of Afrobarometer, and I think those statistics make very interesting reading, and I would encourage that we look at them. I think Rwanda takes the lead because I think they have more than 50%, I think 63% of women in their legislature. So the short answer, Justice Garwe, is the picture is very depressing. We've been talking about this. I was saying to my fellow panelists that I don't like to talk about this topic because we sound like a broken record as women. We've been saying these things over and over again, and the situation is not improving. So we have to think out of the box to say, rather than talking about the things that we've been talking about since Beijing 1995, what is it that has to be done to improve the situation? Thank you very much.
Thank you, Advocate Sakula. At this stage, I will call upon Mary Da Silva, who is on my left, to also come in and give us a perspective.
Thank you, Judge. I too will stand on all protocols that have already been observed. I cannot offer much of a differing opinion from that of Advocate Pansy. The lot of women on the continent is to the extent that they are excluded from decision-making positions, including in political participation. What I want to point out is that when we talk of political participation, we don't only focus on the elite political participation, those women that belong to political parties, those women that are in movements that advance participation of women. We talk about the women on the ground at community level. How much power do they have? How much leverage do they have in engaging or contributing to the political life of the community? Because that's where our politics begin, at community level, before we go to the national level. And if we find, as statistics point out to us, that women have less participation, even in their own families, that of course then translates to the national agenda, where if women do not have the power to make decisions in the family, in the community, and therefore they will not have the power to also engage and contribute to the national agenda. So when we talk about all these instruments that talk about enabling legislative frameworks, what does that mean to the ordinary person who doesn't even know that these frameworks exist? So for us as women, I think, and including the judiciary, it's high time that we go back down to the basics and we talk to the women on the ground, the women that can assist us with coming up with strategies. We've used elitist approaches. We've come up with legislative frameworks. We've come up with the instruments. They are not working. Why are they not working? Because they are not servicing the woman on the ground. Thank you, Judge.
Somewhat depressing remarks, but I think that perhaps is the reality on the ground. But I think the question that follows is, if these instruments, the Charter, the 2003 Protocol, the Maputo Protocol, and then the 2008 SADC Protocol, if these really had any impact on the participation of women in politics, have they? If they have not, what are the challenges? What are the obstacles and barriers that are impeding the participation of women in the electoral process? I think this follows from, I think, the acceptance that we've not been as successful as we would have liked to be. Perhaps I can start with Slakula.
I think from the legal point of view is that some of these instruments are not written in a peremptory language. They encourage states to do this and to take this step, so that's the problem. I mean, if you look at the Charter itself, it doesn't use peremptory language. It encourages state parties to take certain measures. The Maputo Protocol, on the other hand, uses peremptory language because it says states shall take specific positive measures, such as affirmative action and enabling national legislation. Of course, some countries that have ratified these instruments have adopted those affirmative action laws, but implementation of those laws, of course, remains a problem. Look at Maputo Protocol. It says 50% attainment of parity in gender in decision-making by 2015. It's how many years now? 9. We're not anywhere close to that. So what are some of the challenges? I think the electoral system is a problem. If you look at statistics in countries that use the first past the post electoral system, women fare better. They fare worse than in countries that use the proportional representation system. Because in the first past the post system, women have to go out there and campaign in their own rights. What are the challenges there? Influence of money in politics. To go and campaign on your own as a woman, you must have deep pockets. And as women, we are not good at that. And we have other responsibilities as well that make it very difficult for us to go out and campaign in our own right as women. You look at the proportional representation system, what are the challenges? Women were at the mercy of party bosses for them to be able to put us up in the list of candidates. Sexual harassment is a reality in political parties. So we sort of in a no-win situation because we've got so many problems. I'm looking at, for instance, in South Africa, in the local government system, we have a mixed system. Some of the councillors, 50% are elected through the proportional representation system and 50% through the first past the post. What do the statistics tell us? They tell us that only 3 women made it as independent councillors out of 51. Only 3 were elected. And if you look at ward councillors, out of 4,417, only 1,200 women made it. So even the first past the post system is stacked against us as women. So that's one of some of the problems that that we have. And look at the ratification of instruments. Our states, they ratify, they don't implement. Parliaments are weak. They don't hold the executive to account. They don't make sure that the executive adopt measures and live up to their international obligations. Quotas are voluntary. Only few parties adopt quotas, and we don't have legislation in most countries that compel political actors to observe legislative quotas. Thank you very much, Chair.
So I think, in a nutshell, what you're saying is that we do have these instruments, some of them well written, well crafted, but the enforcement of these instruments is lacking. In short.
Yes.
Mary Da Silva.
I'll take it from where you left off, Judge. It's the enforcement that's a clear problem. And these instruments clearly do not have enforcement clauses in them in terms of stating what happens to a state party that does not adhere or that does not implement the provisions of these instruments. We all know if somebody has been found guilty of an offense, one way or another, there is a punitive measure. You pay a fine, community service, custodial sentence, or whatever the measure is, it is there to deter people from breaking the law, basically. But when it comes to international instruments, there is no such enforcement clause. And it allows governments to get away with not implementing through the different institutions that they should implement with. So that's been one of our biggest problems when we speak to international law, whether it's regional or continental or even at the global level. And when we talk about the barriers and the challenges that women face, it goes back again to what I talk about, the basics. It talks about how society views women, the stereotypes, the biases, the roles of women that are placed by society, where a woman's place is not in politics, where a woman's place is basically in the family, even if that woman may be a judge or where that woman is a politician, but still at the end of the day, she's expected to play the familial role, the maternal role in a family. And so these barriers, you know, in terms of what a woman is expected to do and how she's expected to behave plays out even in our laws, where you find that some of these laws have language that is not suitable for women to take up positions of power. So, you know, the societal structures, our traditions, our customs, we are all Africans, and we hold dear our cultures, but how much do these cultures hold back women, or how much do they advance women? And when we come to the laws, again, I will say, the people on the ground do not know these laws. And the people on the ground are the ones that are expected to hold people in position accountable for upholding the rights and promoting and protecting these rights. But if the people do not know their rights, there will always be that clique that will not enforce if they are not forced to enforce.
Advocate Kakula, you wish to add something?
Yes, I just forgot just one point, which I think in the digital age that we are living in is likely to become a problem. It's already a problem. Cyberbullying is real. And it's going to also discourage women from participating. With generative artificial intelligence out there, which is going to be spreading misinformation and disinformation using videos of people and distorting them. That's going to make it extremely difficult. It's already making it difficult for women to take up leadership positions.
Thank you. So what should be done? What should state parties perhaps with the help of the AU, what should state parties do in order to ensure that we have effective implementation procedures that can ensure that these beautiful provisions in the protocol and the sub instruments are enforced, and that they don't just remain empty provisions in these instruments. What can be done? Do you wish to start?
We have had so many recommendations, including in the instruments themselves, on what states should do. These instruments indicate the measures that states should take. The Maputo Protocol talks about affirmative action. It talks about the necessary legal frameworks. But we've seen the weaknesses of the instruments in terms of enforceability. So I think we need to look at the constitutions of these different countries, because that's the supreme law, that's the foundation of any of the laws in those countries. I come from Swaziland. International and regional instruments have to be domesticated before they can be applied. When you look at South Africa, that has a constitution that says these international frameworks become law the moment they are ratified. So we need to have a uniform approach with regard to these, to say, you know, at the continental level, at least for the continental instruments and the regional instruments, these have to become domestic law as soon as they are ratified by the countries. Because the biggest problem with the domestication process, it's a lengthy process, time-consuming, resource-consuming, and it depends on the political will to have that instrument ratified. If it talks about women, it's way down the ladder. It's way down, you know, the issues of priority for a country. And so if we don't have that kind of a country that immediately implements international instruments, that's one of the problems. You look at Kenya as well. Kenya has one of the most progressive constitutions that we have seen, particularly for women. It has, in as much as it doesn't conform to the 50-50 quota, but it has rigid standards at which you cannot amend the constitution in a way that would disenfranchise women, that will make them, you know, have less impact in terms of the political life of the country. So some of those things have to make it into our constitutions. It cannot be left off to secondary legislation where it will become the issue of whether the government or the legislature has the political will to do that. I'll make an example. Our constitution came into force in 2005. And when it comes to the administration of estates, it was said that immediately within the next, it gave a period of time within which the House of the Parliament was supposed to pass a law to amend the issue of administration of estates. But how many years later, almost, 2015, 2005, like almost 20 years later, we still haven't had that amendment because there's the issue of lack of resources to embark on a legal reform process. And so when you leave these things open to interpretation, when you leave it open for government either to do it or not to do it, then it becomes a problem. But when it's rigid and put in as a provision that says it has to be done, and then I think it's a bit better in that aspect.
Advocate, any?
My faith is in the courts, I have to say.
In the courts?
In the courts, in the judiciary, because the politicians have often failed us. And in South Africa in particular, what we have achieved in terms of the implementation of some of these instruments, we achieved because of the courts, because civil society took cases to courts. I'll give two examples. One example is the legislation called the Promotion of Access to Information Act. That act does not apply or did not apply to political parties. It applies to public bodies and also to private bodies, but the definition of a private body did not include a political party. And civil society organizations were trying to use that legislation to request political parties to disclose their private sources of funding. And they were not winning because the legislation did not apply to political parties. And they took the matter to court, and it went up to the Constitutional Court, where the Constitutional Court, using the jurisprudence of the African Commission on Human and People's Rights and using the African Charter, came to the conclusion that the right to vote entails that voters must know, they must have information that will enable them to vote for a particular party. And on that basis, the court declared the Promotion of Access to Information Act unconstitutional to the extent that it did not apply to political parties. Now, that legislation applies to political parties, and citizens can request any kind of information from political parties, which talks to the issue of transparency. And they can also, and what then happened as well was that the act was also amended to make it compulsory for political parties to disclose their private sources of funding. That's one example. The second example was challenging the Electoral Act, because the Electoral Act provided that citizens can only stand for elections through political parties. And the court struck down that. They said it cannot be. The right to stand means citizens can have a right to stand as individuals, not through political parties. So this coming elections, 2024, we're going to have a situation where independent candidates can contest the national and the provincial elections. And these changes, which are significant, did not come about because we have the instruments, we have parliament, doesn't hold the executive accountable, but my faith is in the courts. And I'm saying the courts, if they are independent, the judiciary is our last line of defense, particularly in countries where there is dysfunctionality of the executive and where the legislature is weak. But the judiciary can only become the last line of defense if it is independent. Thank you.
Thank you, Advocate. I think That raises the question, how far have the courts been able to promote the participation of women in elections through judgments, and of course invoking the provisions of the Charter and the provisions of the other human rights instruments. Do we know of cases that have been decided by the courts that illustrate the kind of action taken on the part of the judiciary to ensure that these instruments are actualized in order to promote the participation of women? Do we have any information on the role that we in the judiciary have played in this particular aspect, on this particular aspect?
There's a case that was decided by I think it was the Supreme Court of Lesotho in 2005. It's the case of Mulifitsepe versus the Independent Electoral Commission. And in that case, in 2004, the legislature had adopted a gender-based equity system at local government levels, in terms of which 1/3 of the seats in council had to be reserved for women candidates. I think what happened is that this legislation was challenged. The quota system was challenged as unconstitutional. And the Court of Appeal in Lesotho held that positive measures such as electoral quotas conform with Lesotho's international obligations and constituted a justifiable limitation to the rights in the Constitution. So this was a landmark decision, and that's the one that I came across where the quotas were upheld by the court.
And then none from the other countries in the region?
I searched, I'm not saying, maybe I'm speaking under correction, but the case that I came across, maybe my sister here.
And Mary?
Thank you, Judge. And the reason why the advocate may have come across just that one case is because there are very few cases that are taken up to challenge quotas in courts by women, particularly because of the economic disenfranchisement of women. But I think Sally might have a better perspective on this one if she's online. But one of the things that sticks out for me when you ask the question about whether the courts are promoting the women's rights to political participation is that generally, from what we observe from civil society, what we observe is that generally courts don't see themselves as having a mandate to promote, but rather a mandate to interpret the law. And when interpreting the law, we also hold the perspective that they use the minimalist approach, something that will not, send shockwaves in terms of the jurisprudence, something that will not overhaul the jurisprudence overnight. So the mandate of promoting rights from the bench is not something that the courts hold a view on. And, we had a case in Swaziland where a woman was discriminated by the chief of her area and telling the constituents not to vote for her because she was in mourning. She was in mourning gowns. She had just lost her husband. And this was an act of discrimination. She took the case to court on two grounds. The first one was the issue of having the ballots, the secret ballots being counted in a transparent manner because she had lost the elections and she felt that she was hard done because she did not have an idea of how the secret balloting went. but she felt hard done by the fact that, when it came to her candidature, it was because of the discriminatory nature in which the chief of the area treated her. And he being a person of influence, most people then listened to what he said. At the end of the day, she did obtain an order that allowed for the secret ballots to be counted in a transparent manner. But at the end of the day, the chief was not made to withdraw his, withdraw his statements that he made in public, and she lost the elections even at a further stage. So these are the kind of things that women face, and when one woman takes it up to court and challenges it and doesn't get the kind of, result or judgment in her favor, it sends a message to other women that says, even if you did have the economic power to take the matter up to court, you will not get a favorable result. And therefore, it leads to women not challenging some acts of discrimination and violation of their rights.
Thank you, Mary. I'm not sure, Mr. Tsunga, whether the Ambassador Hamad and Salim Ngube, you did not succeed. Okay. Okay, thank you. I thought maybe they may wish to comment on the remarks by the two panelists. Lastly, I think the one question that I would want to pose is there any role that other stakeholders can play to ensure the participation of women in elections, and to ensure that women in particular are protected during the election cycle? With stakeholders such as have in mind, such as the media, civil society organizations, EMBs, regulatory bodies in some instances, etc., etc. Is there any role for these stakeholders to play in this regard?
I'm going to mention, Justice Garba, just two stakeholders in the interest of time. One of them is the EMBs. If you look at the legislation in most of our countries, they have an electoral code of conduct. And this electoral code of conduct is supposed to be enforceable. And in our country, it's even enforceable by the electoral court. And the law provides that the chief electoral officer can even institute civil proceedings against a political party that has signed electoral code of conduct and that does not adhere or abide by that code. And the code in South Africa also has a clause on the participation of women. This has never been used. I mean, I was also in elections, and in my time, we never used the code of conduct to see whether we can push the boundaries and see if we can force political parties to include women, more women in their lists. The second one is the organization that I'm representing, which is the Information Regulator. And because wherever I go, I try to preach the data protection gospel, because data protection is now the new human rights in the world. And I see even in this conference, our photos are being taken and the video is being taken. Nobody has asked me for permission, consent to take my photo or to take my video, because in this world that we live in, if people fill in a conference registration, there has to be a clause to say, do you consent to your video or your photo being taken? And in my country, if you do this, my organization can take action against you, and we have, we can even issue fines of up to 10 million rands. So I'm just saying that that was on a lighter note, that if you look at issues of disinformation and of misinformation, fake news, what is the role of these regulatory bodies. I mean, disinformation, if one uses artificial intelligence to distort my video and uses it, you know, in a way that normally what happens, my video, my photo is personal information. So whoever uses my photo in that way then violates my right to privacy as it relates to data protection. This is a new area. I think we need to look at these new areas of law and see how we can use them to counter disinformation and misinformation. And lastly, when Dr. Khabele was speaking, I said, in jurisdictions such as ours, where the right of access to information applies to both private and public bodies, what can be done to use that piece of legislation in South Africa, for instance, to hold digital platforms accountable? Nothing prevents anyone from asking information from a digital platform to say, can you give us information on how you deal with disinformation and misinformation, the budget that you allocate towards it, and also give information to the researchers to look at this so that we can deal with this. And I think these are new frontiers that we have to begin to look at, because this is the new age that we are in. The human rights violations happen online. And I think the courts also have to be prepared to look at this matter, because they're going to be flooded with these kinds of cases very soon. Thank you very much, Judge.
Mary, any comment?
Thank you, Judge. With Advocate Pence's talking about the digital space and misinformation and disinformation, there's also something that is now very rife. There is something called hate speech and harmful content. You know, we say things that are harmful to the next person. We say things that are harmful to the woman's prospects of being elected, or a woman's prospects of actually even being a voter. We have to find a way of curbing this, of combating hate speech and harmful content at a national level, because it is in what our politicians say, it is in what our community leaders say, it is what our political opponents say about us that then create an image of us. And this image that they create, or the things that they say and express about us, opens us up to violence, including physical violence. So just because somebody influential has said something about me and it's out there in the public domain, either they said it at a rally or they've put it on social media, it then fuels hate, it fuels and incites violence against the woman because she is stepping into the men's world. That would be my first one. The second one would be looking at the issue of, when you talk about taking decisive legal measures, these measures are not enough on their own. There has to be collaboration across stakeholders. Members of the judiciary are here today. They are hearing some things perhaps for the first time. And just by hearing something for the first time doesn't mean that you'll immediately assimilate and be able to become an authority on it. We have to collaborate with one another in a way that will bring all our measures together. If I come from the perspective of the woman human rights defender at the grassroots level, and I come up with a solution, and the lawyer in the room will tell me that your solution in terms of the law would work in this way, then perhaps we can combat quite a lot of the ills that are happening. But without collaborating with each other, there's nothing that we can achieve. And I think, you know, when having civil society in a setting with the judiciary as well, it opens up the door for the judiciary to appreciate the fact that there may be other persons that are a bit more knowledgeable on an issue that could actually bring, you know, some clarity and influence some of the decisions that may come out of the courtroom. And the last one that I want to say is that until we have an understanding and appreciate the fact that all rights are interrelated, the right to political participation cannot exist outside the right to life or outside the right to liberty. They are all interrelated, one way or another. So if one right is violated, then all the rights are violated. And if we are able to put it in our legislation or legal frameworks in whichever way that we want to do, we'll be able to make sure that the one right is protected, and therefore there'll be a domino effect of all rights being protected, and and that will allow for women to effectively participate in politics, because if I have the right to express myself, I will be able to speak. If I have the right to associate with other people, I'll become a member of a political party or a member of a movement that will advance our agenda. If I have the right to live peacefully without any violation of my security, then I'll be able to thrive in whatever sector that I'm living in. Thank you.
Thank you, Mary. I am aware that this session is spilled over into, I think, the lunch break, but it is also fair to say that the session started a bit late. I think at this stage, I open the floor to very quickly.
Can give about 10
Yeah,
minutes.
about, I think about 10 minutes. I open the floor to comments, questions. Okay. Do we have a microphone? Oh, okay.
Thank you, Justice. Let me thank the panelists for a very rich discussion, Advocate Tlakula and Mary. Really appreciate it. I don't have a question. Just want to contribute to the discussion. Yes. One contribution that I think I want to tap when we were looking at the stakeholders. Am I what? Oh, I use this one, huh? Okay. Thank you, Justice Khabele Matlosa. Just a contribution to the discussion, which is very rich. I wanted to bring to the table what I will call an elephant in the room here, in respect of the inclusiveness of our politics and elections. And the elephant I want to bring in the room, I want to identify that's in the room, is political parties. Political parties. And until and unless we have an institutionalized intra-party democracy, we're not going anywhere, frankly. Because these parties, they're a law unto themselves. At one point, they are private. At another, they are public. You never know. You never know exactly their identity. They have youth leagues. They have women's leagues. And these are the majorities in our populations, all of us, all the countries represented here on the continent. Women are more than 50% of our populations, every country. And youth are plus minus 70%, depending on how you define them, whether it's the UN or AU, right? So, but they are organized within parties as youth leagues or women's leagues without power. They are just there, ghettoized on the margins of the party. They are remembered only around election time. Yes, to mobilize votes. But as social groups that are vulnerable, that are marginalized, their interests are not taken seriously by political parties. And that's why even in the main leadership structures, they are also marginalized. So my proposal is, on this discussion, I think we should also identify this as a big problem. Intra-party democracy, which is lacking in many of our countries, and link this to violence that marks our politics. Then influencing women and youth to dissociate from elections, hence high turnout, that voter turnout that we always experience. I wanted just to put that on the table, Justice.
Thank you, thank you, Dr. Matlosa. I thought I saw a hand. Justice Musinga from Kenya. All right, from Kenya.
Let me also thank Advocate Pansy, Lakula, and Mary for the very good presentations that I have made. My question is to Advocate Pansy. I like what you say that one, that it is only, I think, Rwanda that has achieved the gender parity so far as you are aware. And my first question is, how did Rwanda achieve that? And how can other African countries emulate Rwanda in that regard? Number two, you say that your faith is in the courts. A majority of us here support the full and equal participation of women in elective politics. But democracy is a game of numbers. The question I would like to ask is, can you suggest ways in which African judiciaries can promote participation of women in elective politics? I know in Kenya, the Supreme Court, led by Chief Justice Emeritus Maraga, gave an advisory opinion to our president a few years ago to dissolve parliament because it had violated a constitutional edict in having at least 2/3 gender representation. But that notwithstanding, an opinion coming from the highest court, from the Chief Justice, nothing was done. So what more can these judges or judiciaries in Africa do? Thank you.
Justice Chinengo.
Yes, thank you very much. And thank you for the panelists and the good presentations they've made, very enlightening. I have just one question. I must preface my question by saying I'm very sympathetic to the plight of women generally across Africa. But we know that governments thrive or are basically rule-bound. Governments run governments through legislation, through regulations, through statutes, and so on. And good governments depend on good public administration. If you go to the Zimbabwe Constitution, we have a chapter 9, on the values and principles of governing public administration. And one of the values, or subsection 2 thereof, subsection 2, it is subsection 2 of section 1. It reads as follows: appointments to offices in all tiers of government, including institutions and agencies of state-controlled entities and other public enterprises, must be made primarily on the basis of merit. My question to the panelists is this: how do you balance the issue of women advancement with merit? I'm aware that there are many women who have risen to high posts on merit. And my question is simply that: where do we strike the balance between merit and the positive discrimination towards women? That's my question. Thank you.
Thank you, Justice Chinengo. I don't believe that I see any other hand that is up, but we do have, I think, 2 very quick interventions. I think the first by Mbe Winner. She's online. very quick remarks. Mbe Winner.
Mbila Winner, thank you. Thank you, my lord. And thank you to all the participants. I'll ride on all. Can you hear me?
Yes, we can hear you.
Thank you. Mine was just a short contribution to say that, basically to say that it is very sad in this day and age to note that as women, we're still fighting for a seat at the table in everything, politics, corporate bodies, in everything in the 21st century. When we have trailblazers who have gone before us, who have fought for us to the right to vote all those years ago, the right to own property. We've always, as women, always had to fight for a seat at a table. And in this day and age, the 21st century, we're still doing the same. Basically to say that we are just as capable as, on the light note, as our men folk, as people, trailblazers such as Amelia Earhart, who was a sole woman's pilot who flew solo across the Atlantic Ocean. So my contribution basically is to say we need the support of our men folks, that we are just as capable, and we shouldn't be fighting this fight alone as women, because we bring so much to the table, both in the political arena, both in on the bench. I'm sorry I didn't introduce myself. My name is Justice Winner from Zambia. I'm currently recently arrived at the Livingstone High Court. I'm a High Court judge. So I feel very strongly about women's rights. I think in the sense that maybe it's in the DNA. My mother was a politician, and I chose not to go that way. I chose the legal route. But she led the women's delegation, the Zambian legal delegation, women's delegation to the Beijing conference. And for her, it was the issue of us having so much to put at the table, in that we are more than just people who would just be there dancing at dancing troops just as entertainment. We have the intellect, we have the initiative and the intuition to be able to contribute in all spheres of life. So, just to say that we are equals, we are helpers in the weaker sense, in the physical sense, but we are equal to our men folks. And this fight should not be for us alone as women, but for our men folk as well to fight this fight with us. Thank you.
Thank you, Justice Winner. And I think very quickly, we also have Monica Mense, very quickly. Is she online? Cheers.
I would like to ask them what they think about the role of women wing in political parties. Are these not the roots of discrimination? And why should we, the women in politics, accept that role of women's wing? What is the purpose? How has it advanced the participation of women in politics in terms of leadership in a political outfit? Thank you very much.
Thank you, Monica. I will ask the Advocate Takula to comment, and then Mary.
Thank you very much, Chair. The question of merit and women, I think I will leave it to my sister to respond, but I hope that question does not entail that. Why does merit has to feature when it's women? I mean, when we look at merit, we should look at merit in women and men if they are running for office. Unless I misunderstood, because I don't understand why when women have to be appointed, then the issue of merit comes into it to say, how do we balance merit and so on? That should also apply to men equally. But I'm sure my sister will weigh in on this question. And, Justice from Kenya, I thought you were going to ask, what can the judiciary do to increase the number of women judges? Because that's a problem as well. That has to be looked at. Yes, but I think that when it comes to participation of women in electoral politics, I think the judges are constrained in what they can do, because the judges decide cases on the basis of what comes before you. So I think it's for civil societies, for other actors to bring cases like that before the judiciary, for the judiciary to then pronounce themselves on that. The last question, I think I need to respond to Dr. Kabele. The access to information legislation in South Africa, which applies to political parties, civil society has to begin to use that piece of legislation to ask for information from political parties, including their internal democratic systems. And I am trying to push civil society organizations to do that, because we have not used that piece of legislation effectively. Thank you. I'll leave other questions for my sister to respond.
Thank you. I know it was a comment, but Ntate Matlosa, when you talk about inclusiveness, I think it's only my duty to also highlight the fact that when we talk of inclusiveness, we're not just talking about men and women. There are other gender identities that are out there. There are other lived realities that then makes people identify with a certain label. So it may be a topic for another day, but when we want to talk about inclusiveness, we've got to look at it across the diverse identities that people have. And then in terms of Justice Chinyengo, he said, how do we balance between women's advancements and merit? I think Justice Wiener, in her comment, answered that. Women are equally capable. Women are equally competent. Women, when given the opportunity, will actually deliver on what they have been expected to deliver. Women are intellectuals, they're innovators, they find ways around situations that may seem insurmountable. But all you have to do is give women a chance. Women who are fit and qualified for that position. Because the flip side of it is that when we talk about affirmative action, what we normally do is just take a woman and put her in a position without regard for her competence or capacity to actually deliver on that. So there's always issues of tokenism that come out to play when women are appointed, and we're always setting them up for failure. But if you appoint a woman that is qualified, competent, then you will see results. When you talk about political parties and women's wings, I think this was something from Monica that she said, I also don't subscribe to having a women's wing in a political party. Well, we don't have political parties in my country, but I don't subscribe to having a women's wing because it then sets apart. It becomes a discriminatory issue to say, if you want to discuss issues as women, you have to discuss them in the women's wing. You cannot discuss them in plenary. And when you come to plenary, you must always discuss issues that will speak to the entire political party. Women's wings and youth wings are only used to fit the purpose of the political party. When it comes election time, it's the women, it's the youth that are the ones that are campaigning for the men that fill the political parties, the leadership structure. Because if you look at the leadership structure, you will find predominantly men. If there's a woman, there's just one or two, and it's normally the gender officer or deputy something in that structure. So those are just functionaries. They fulfill a certain purpose. Married women, again, there's no issue. Why do we have to differentiate when it comes to women? There's a different set of rules for women and a different set of rules for men. Not only in political participation, but everywhere, because the moment a woman ascends to a position of power, then we look at issues that we can use to pull her back. Oh, she's married, she won't have time for the work, she has to mind the children, forgetting that the husband has the equal responsibility towards child minding and making sure that the family is looked after. So that different set comes from what I mentioned earlier. the traditional way in which we see women, the stereotypes, the biases, and they also play out even in the judiciary, even in the corporate sector, even in civil society. We have been socialized in such a way that we view women in a certain light, and once they are sent to positions of power, then that different set of rules comes to apply to them. I think, yeah, I think that's where I can leave it.
Thank you very much, Mary. I know that we were well beyond the time that we're supposed to adjourn for lunch. The intention was not to violate your right to lunch at 1 o'clock. But obviously, this came about because of the problems that we have with technology. I take this opportunity to thank Advocate Pansy Kakula. I hope I've been able to master the pronunciation, Kakula, and Merita Silva. I think they've done very well. They came up with quite a number of remarks and comments that I think we all should consider further. At this stage, I would like to ask all of us to join me in giving them a round of applause. Thank you very much, Mary. Thank you very much, Patty. Thank you. I would now ask Mr. Tsunga if there are any announcements before we. Okay, thank you.
Thank you. Thank you very much, Justice Garwe, for executing the session extremely well. And I think the change into a conversation made it quite lively. And yeah, we've sort of run into our lunchtime, but I have a feeling that we still need, for purpose of making people totally refreshed, to give the hour for lunch that we needed. This would mean that we will have to come back here at 2:30. And then in the meanwhile, I'll be consulting with the leadership of the Electoral Justice Network how to reconfigure the program, because I'm told this room is needed at 4 p.m. or 4:30 p.m. latest for them to prepare for the dinner. So I'll ask that you also remember on the itineraries, there's a list that is circulating to reconfirm your itineraries to give the Judicial Services Commission an opportunity to support you as you leave Victoria Falls. So for now, I'll ask as per practice that we stand as the Chief Justices leave, and then we leave for lunch and come back promptly by 2:30.
Pois Deixa eu falar chidi. Minha de so that chidi. Bye bye so ma skill. Ndo nice hapo. Right.
These are the names.
Yes, my lord.
My name is not there.
That's the first one in front, MB.
Okay, okay.
Yeah, I think you're on break.
Okay.
You're on break.
Okay.
Welcome back, Chief Justices, Justice Mba, distinguished colleagues. Yeah, we still intend to finish on time at 4 p.m. So there's going to be some acceleration process. We'll be moving at the speed of an unidentified object. On the next session, I'm going to invite Honorable Chief Justice Mapalala to come forward to lead your esteemed panel or esteemed keynote presenter. Chief Justice Mapalala is the Chief Justice of Eswatini, is currently the chair of the Southern and East Africa Chief Justices Forum, which is a forum of Chief Justices from East and Southern Africa. And he was recently elected by the collective of our Chief Justices to lead the region in terms of supporting strengthening of our judiciary's access to justice and the rule of law. And I've generally known Justice Mapalala for a long time, and really esteemed CJ, over to you.
Thank you, Program Director. I realize. All protocol observed. I realize that my biography is not included in the program, but I understand. Maybe I did not forward it to the organizers, but I do confirm that I'm currently the chairperson of the Southern and Eastern Chief Justice Forum. Briefly, I did my law degrees at the University of the Witwatersrand in Johannesburg. And thereafter, I practiced law as an attorney for a period of 20 years, after which I was appointed as a judge of the High Court and subsequently as a judge of the Supreme Court. I was appointed as Chief Justice in 2015. I'm still the Chief Justice. I was at the university together with my friend there, who is the director of the network. We were together at the University of the Witwatersrand, but he was ahead of me. When he completed, I was doing my first year. The topic for today, for this session, is the electoral judges, the role of the electoral judges in protecting free voting and tackling political corruption. I've got one keynote speaker. That is my friend and colleague, Justice Maraga, Chief Justice Emeritus. He's having 30 minutes to make his presentation. And again, the session is based on the African Charter on Democracy, Elections, and Good Governance. I understand from the program director that I have to run at a great speed because of time constraints. Accordingly, I will invite Maraga, my friend and colleague, to come forward. You have 30 minutes, Chief Justice, to make a presentation. Thereafter, we'll have time for the plenary.
Thank you, CJ, for welcoming me. The Honorable Justice Malaba, CJ of Zimbabwe, Deputy Chief Justice of Zimbabwe, the Honorable Chief Justice here present. Ladies and gentlemen, good afternoon. The danger of speaking just before lunch is that you get people who are hungry. You're speaking to people who are hungry. And more often than not, they're not listening to you. When you talk to people in the afternoon, you risk having them going to sleep. It is worse when you are told that there is the pressure of time. Don't worry about that. Due to the pressure of time, I'm not going to read my presentation. You will get copies later on in the program. But I just want to say this. Though respect for human rights, the rule of law, and the separation of powers, as well as the existence of transparent, responsive, and accountable government are critical pillars of a democratic government, in my view, elections are the soul of every healthy democracy, ensuring that government authority derives from the will of the people. Credible elections not only confer government with legitimacy, but also sustain the democratic order. As such, elections are the legitimizing process that grants elected leaders with the wherewithal to govern. Legitimacy is grounded on the constitutional concept that governments derive their just powers from the consent of the governed. You know the famous quote from Abraham Lincoln, a government of the people, by the people, and for the people. Acceptance by a society's majority that their government is legitimate makes the social order more efficient, consensual, and just. If a government is not considered legitimate, it will find it very hard to even regulate social order in a society. The African Union, through the African Charter on Democracy, Elections, and Governance, recognizes this imperative. The preamble to the Charter seeks to entrench in the continent a political culture of change of power based on holding of regular, free, fair, and transparent elections. Already other many speakers have spoken to the Charter, and one of them is none other than the author himself, Dr. Kabele. In a nutshell, the African Charter on Democracy, and conventions require state parties to legislate for and conduct regular and transparent elections. The constitutions of most African states have vested in the courts the jurisdiction to resolve electoral disputes, and as such made the courts the ultimate determinants of the legality and the legitimacy of the electoral process. I know it as a fact that there are some constitutions, like the Kenyan one, the Zambian one, and others, where the president will not be sworn in until election petitions, even against his election, are disposed of. So you see the importance of the court in such a situation. The question is, have the African election courts played their role? I will revert to this question later in my presentation. But what I want to say is this: Kenya, because I'm giving the Kenyan experience, as it were, domesticated the major principles of the African Charter on Democracy by requiring the electoral system in Kenya to comply with all the general principles of inter alia, free, fair, transparent elections conducted by an independent body. The Constitution goes ahead to set up that constitutional body, the Independent Electoral and Boundaries Commission, which we normally refer to as the IEBC. One of the functions of the IEBC, and for purposes of this presentation, is to regulate the amount of money that may be spent by or on behalf of a candidate or a party in respect of an election. That's what we are looking at in this session. The rationale for this, one author said, and I quote, "Campaign finance legislation is based on the premise that money is a significant factor in electoral success. Legislation therefore attempts to promote financial equity and fairness, primarily with respect to election campaigns." Some have referred to campaign finance legislation as legislation designated or designed to create a level playing ground, end of quote. I saw 3 landmark cases, one from the US and 2 from Canada, all of which underscore the importance of the rationale of election campaign finance regulation, as not only meant to prevent undue influence of donors on office bearers' decisions, but also to counteract the capacity of affluent members of society to exercise a disproportionate influence on the election by dominating the debate. The Kenyan experience with the election campaign financing goes back to 2007, when there was a provision in the old legislation, now repealed the Elections Act, and the National Assembly and the Presidential Elections Act, which provided for a ceiling of the amount a candidate would spend. Those legislations were repealed ostensibly on the ground that they were difficult to enforce, or the limits that the Electoral Commission was setting were unrealistic. You know, Kenya has had its own history. Many of you know about what Kenya went through in 2007, 2008. the post-election violence after the elections. A commission was set up, which was headed by gentleman from South Africa, Krigler, to investigate the cause of the violence. One of the problems it identified was one of using public resources, government vehicles, civil servants, including even police in presidential election campaigns. So come the time of making the 2010 constitution, this was a major issue. The public were categorical that they did not want the government or any government officials to use government resources in his campaign. Pursuant to that, a provision was put in the constitution to allow the electoral commission to cap and come up with limits of spending and even the amount of money they could receive as donations from various institutions. That act has not been implemented to date. Why? The politicians have made sure that it is not implemented. In fact, the IEBC has come up with several regulations, draft regulations, to enforce the act, but they have all, in one way or the other, been shot down by the parliamentarians. So those limits have not worked. Between 2016 and 2022, Parliament rejected about 4 proposals by the Electoral Commission to put limits to the amount that anyone could spend in the elections. And when they were all rejected, two civil societies went to court and filed a suit. That suit, one of the prayers was to declare Section 29 of the Act unconstitutional because it required the Electoral Commission to take the regulations to Parliament for approval before they could publish them in the Kenya, in the Kenya Gazette. That declaration was made, but the court went further to say that IEBC itself had not followed the law. They had not given the required notice of not less than 1 year before the next general election, so they lost. Some other groups were celebrating and saying this has done very well, but in my view, not much will come out of that act. Why? There is another act. We call it the Statutory Instruments Act, which requires all, should I call it subsidiary legislations, to be approved by Parliament before they can take effect. And the regulations by the Electoral Commission to set limits within which candidates can operate are considered as subsidiary legislation, which must go through Parliament. So those are the challenges that are there, and it remains to be seen how IEBC is going to deal with that. On the actual, I'm just rushing over. On the actual issue of abuse of resources, these have also come to court. The major one that has come to court is use of public resources. And there has been a lot of argument as to what constitutes public resources. Who is a public officer? Who is not supposed to participate in politics? And that brought in quite a number of issues. So come 2013, the executive amended the law to ensure that the cabinet secretaries are removed from the definition of public officers. And you know, the, the cabinet secretaries, these are the ministers. They are ones who control the funds in the ministries. Of course, we know that it is the permanent secretaries who are the accounting officers, but the ministers are the bosses of the permanent secretaries. So that is something which is there. It has not come to court as to how the ministers are going to be controlled in the use of public resources during the campaign. As I said earlier, one of the major problems that was identified in 2007-2008 violence was the use by the incumbent of government resources. And the Kenyans are very, very particular when they see cabinet, the politicians using advantage of their position and using the resources to carry out their campaigns. So a lot of argument has come up. The president is there. He is the president of the republic, but he is campaigning, and you get in his entourage even up to 20, 30 vehicles belonging to the government in the campaign. So the issues are being asked, is this not misuse of public resources? But others are also arguing and saying, look, the president is wearing two hats. At the time of campaigning, he has not surrendered his powers. As the president, he must be there. He must have security, he must have that. All those are issues, but they have not come to court. But I can assure you that they are live arguments. The other issue about public resources is one of the MPs enacting what we call the Constituency Development Act, which authorizes the Treasury to release some funds and give to the members of parliament themselves for development in their areas. These funds are not being given to the senators. You know, we have two houses. They are not being given to the senators. They are not being given to the women representatives. You had our sisters talking about women being discriminated against. They are not being given that. So the issue is, the argument is, why give it only to the members of parliament? First of all, from the National Assembly, not from the Senate. And that has gone to court. I will stop there because the matter is sub judice. I wouldn't want to comment any further on that. So those are the kind of things that have come to court. The other one is the issue of vote buying or bribery. Bribery is one of the election offenses under the Election Offenses Act. But this is one allegation which petitioners have found it very difficult to prove in court. Why? Because the election courts have held that an allegation on a criminal offense must be proved beyond reasonable doubt as the standard of proof. The challenge that has come with that is this. The Election Act says upon proof of that, the court is supposed to make a finding that the respondent is actually guilty of that offense. Then report the finding to the DPP, Director of Public Prosecutions. Some lawyers have come and said, look, we have this principle of double jeopardy. A high court trying an election petition makes a finding that somebody has committed an election offense. This person is reported to the DPP, and if investigations are carried out and is taken, he will most likely go to a magistrate's court because those kind of cases are not tried by the High Court. So you can see the conundrum in that kind of situation. Is the magistrate going to upset the finding of the High Court? Those are the kind of challenges that are there. But the reporting is also there in the Constitution. If you've been found to have committed an election offense, the Constitution requires that you are reported to the Electoral Commission so that you are barred from contesting, especially in the next election. And you know that is something that has been fought seriously, even from the 70s. There was one MP who was barred from contesting the next election, and he was a friend of one of the late presidents. The late president got the Attorney General to amend the law and give the president power to excuse him, which is what was done, and they contested in the next election. So you can imagine what that is. So that issue, because of that, is a problem. The other problem that has come to court, and somebody mentioned it here, is ballot box stuffing. Previously, we had elections in polling stations, and all the ballot boxes would be sealed, carried from the polling stations to the tallying center. In most cases, those tallying centers were the district headquarters. The country then had several district headquarters, and that's where they would be taken. So you could find that elections or ballot boxes from about 5 constituencies are taken to one polling center where they are counted. On the way from the polling station to the polling center, very many things happened. Very many things happened. In one incident, several incidents, I don't want to mention names. The counting is going on. If that business was not done in the way, when counting is going on, bullets are shot in there, the light goes off, and within a short while, the lights come back, and then now you start and say, okay, where did we stop? During that time, you find that some ballot boxes have been brought in and mixed with the others. This is exactly what happened. So the civil society and some lawyers went to court, and they got the court to rule. They got the court to rule that all ballot votes are counted at the polling station, and that the results recorded in that polling station cannot be changed. Cannot be changed at all. This is what informed the electronic transmission. Before we come to the electronic transmission, those results were recorded in the polling stations, and some forms were completed, so that the results from a polling station will show who was, especially in the presidential election, who was the majority of the votes from there. As those forms were being taken now to the National Tallying Center, things happened again on the way. In short, those forms were tampered with. So the opposition and the government came together and said, look, we want to sort out this problem. They came up with an amendment to the Elections Act and they introduced a section that requires that upon completion of that form is scanned and electronically transmitted to the National Tallying Center, the Presidential National Tallying Center, in the presence of all the agents, so that if you have those results and then verified by the physical forms that the returning officer would now take to the tallying center. This is where the 2017 decision, that's how it came about. Some of those forms could not tally with the results transmitted. In some stations, they refused to transmit those results because, I mean, things were supposed to be done. You are told that a given station in Nairobi or in one of the urban centers, that there was no connectivity. And the people come from from institutions next to the tallying center where they said, look, connectivity is very good here. So that's how it came to that. So those are among the challenges that were there. Ladies and gentlemen, my lords, the judges, the Supreme, I mean the Chief Justices, I earlier posed the question of whether or not the courts have played their role as they are supposed to play their role. With the constitutions on the continent giving the courts the authority to determine the legality of election, have the courts played their role to ensure that that is what is happening? In other words, have the courts held the executive and the legislature to account? You must have heard this, I heard it many times, what they call the counter-majoritarian rule, that judges are not elected leaders, politicians are elected leaders. What they are trying to say is that they have a better say than the judges. My argument on that is that we are given, I mean, the powers by the Constitution. Like our Constitution gives the judiciary the judicial authority to decide, I mean, cases that come before them. Just like it has given Parliament authority to legislate and the executive powers to exercise. So, my colleagues, don't buy this argument. Don't buy this argument that you are not elected, so you are like, it's like you are a child of a lesser what? Don't buy that. You have a duty. You have a duty as judges to enforce the Constitution. You are the custodians of the Constitution. I ask myself whether or not we're dealing with this. Our sisters who came here, were asking whether what the courts have done to assist them play their role. And Justice Musinga mentioned about the advisory opinion that was given to Parliament. Justice Musinga, the opinion was given by the Chief Justice alone. The Constitution places that duty on the Chief Justice, not even the Supreme Court, on the Chief Justice. Upon receipt of a petition to, if he finds merit in that petition, to advise the President to dissolve Parliament. And the Constitution goes ahead to say that upon that advice, the President is supposed to dissolve Parliament. Just before I exited the office, I had about 8 petitions on that. And I sought advice from a colleague, some colleagues. They said, look, deal daddy and get out, leave it. Leave it. I decided to deal with it, and I dealt with it. I paid for it. I paid for it. Some MPs, including mine, refused to greet me thereafter. What am I talking about? We have a duty, we have a role and a major role to play in the democracy of our countries. The last time I checked, Africa is the richest in natural resources. It is estimated that 8.3 trillion US dollars worth of natural resources are in Africa. With these riches, how come that our people are wallowing in poverty? Have we judges contributed to this very sad and humiliating state of affairs? In line with the shift of policy that Dr. Marcela talked about, from non-interference to non-indifference. Is there a role we can play? Is there a role we can play so that we change the narrative? Is there something we are not doing right? My lords, you are better placed to consider that and answer and see what should be done. I'm retired. Thank you very much for listening to me.
Let's give him another round of applause. Thank you very much, my Lord, the Chief Justice, for your presentation. I'm not going to summarize your presentation. You have made a very good job in your presentation, and you have stuck on the time restrictions that have been made available to us. I will now invite comments and questions from the plenary. Do I have any people who want to? Yes, who wants to make comments or want to ask questions from the Chief Justice Emeritus, or you have heard everything that you need to hear? Yes, Doctor.
Thank you, CJ, and allow me to extend our gratitude to Justice David Maraga for a solid and thought-provoking presentation. Greatly appreciated. I have 2 points, very brief, that I want to propose to the organizers. No, one is to the organizers. Another one is it's a comment that I'm going to beef up the presentation. The first is a simple one. Can the organizers please make an effort to do solid case studies of Kenya and Malawi, the 2 cases that we have referred to during this conference, 2017 in Kenya and 2019 in Malawi. I think those 2 cases need to be documented as important case studies on safeguarding electoral justice. I think that there's a case that can be made that AEJN Justice Mba, please put some effort to, you have technicians like Arnold Zunga with you, and a number of them, that can put together this case studies for our benefit. That's my first proposal. The second issue is the corruption that Justice referred to, Justice Maraga, in his presentation. And he made an interesting reference to this so-called constituency development funds. I think that there is a case to be made that, and this again goes to show the road in our political systems, that it runs deep and involves a lot of corruption. I think that EMBs working with the judiciary and anti-corruption bodies really have to do a lot to fight political corruption jointly. This constituency development fund, it used to exist in my own country, and we used to get bizarre stories about those funds. I remember one MP had been given that the money, and the money disappeared. The entire lot disappeared. And he said, you know, his justification how the money disappeared. He said, I was carrying the money to a meeting in my constituency. Then it was raining. Said it was raining. So I tried to cross the river, unaware that the water was too much. That is that. In order just to save my life, I just let go of. Oh no! Honestly, and these are MPs. These are honorable members of parliament. Saying no, I was overwhelmed by water. You know, in the middle of the river. I underestimated the current. Exactly. Then in the middle of the river, I said, now this is too much. I think I better just let go of the bag, because I value my life more than this bag. Honestly, so how do we have leaders like that? Seriously, and the man was gone, never came back. So I think, in a nutshell, really this issue of corruption, political corruption, needs a concerted effort by the police, by the judiciary, by the anti-corruption body, by the EMB as well. That's my proposal, CJ. Thank you so much.
Thank you, Doc, for the comments. Another comment or question? Yes, over there. Yes. Yeah, your name?
Chinengo.
Can you give him a microphone?
Yes. Is the microphone coming?
Votre micro, s'il vous plaît.
All right, thank you very much. Thank you,
Merci.
CJ Maraga, for a very enlightening presentation. I was particularly touched by the
Claire,
statement that courts must play their role. My question in that regard is
ma question donc à cet égard,
proceeding from the premise that the courts, the judiciary is the other arm of the state. I think the executive and to some extent parliament, they defend their spaces. But I don't see that much defense from the judiciary. How do you think the judiciary, chief justices in particular, should they ensure that their spaces are properly defended and effectively defended? That is the one question. The other point I want to make or a comment is what Professor Machosa said in regard to the organizers, the Africa Electoral Justice Network should endeavor to. From the presentation earlier in the morning, two questions arose in my mind, but it's linked to what Dr. Machosa has
J'ai
said.
des questions, mais liées à cet exposé qui vient d'être assuré.
Have we taken sufficient introspection ourselves as courts to deal with what comes before us? I remember in one of the comments, CJ Maraga stated that the courts are at the tail end.
Il a dit que
while we are at the tail end, what is it we are doing well or not doing well when matters come before us? It's one thing to be diversionary and say the problems start with the electoral management bodies and things like that. Things happen down there, injustices caused. But the challenge for the courts, I think, is right at the tail end. What are we doing? Because if we don't introspect and say to ourselves, where are we going wrong? We can approach it in a diversionary manner, saying, oh, it all starts with everybody else. We are right at the end. There's very much we can do. I think there's a lot that can be done. Then, in respect of the study, just to add on the study,
Je reviens maintenant à
l'étude the Africa Electoral Justice System, if they find it fit to do so. We are talking about a shared jurisprudence.
Ici, on parle d'une jurisprudence
earlier on in the morning, people talked about the standard of proof and the burden of proof.
De la charge de l'épreuve.
And the two distinct approaches emerged. Malawi,
il y avait
in
des
some
approches
respects,
qui ont
together
été
with Kenya
proposées, le
and
Malawi,
Zambia,
le Kenya, la
and
Zambie,
the other countries
des approches un peu différentes.
with a different approach. I think a study would also help.
Je suis d'avis que
Because in some of the,
l'étude
especially the Roman Dutch jurisdictions, the question of the standard of proof is basically established. That is merely beyond reasonable doubt, if I'm correct. And if we talk about a higher standard, just like saying to somebody, you succeed if you jump higher. But the question might be, how much higher? So I think a study is necessary to articulate the jurisprudential basis of having a standard in between balance of probabilities and beyond a reasonable doubt. What standard is that? Because it might be a problematic standard to apply in a concrete situation. So I would recommend that for study. Similarly, the question of the burden of proof. In our jurisdictions, especially Roman Dutch jurisdictions, the burden of proof remains on the person making the allegation. But the evidential burden can shift. So a study would be able to articulate the issues that are arising within the jurisdiction, within the different jurisdictions, because we are talking about trying to standardize our approach to electoral matters or electoral litigation. So I might wish to have any comment from the panelists on that. Thank you very much.
Thank you. Do you want to respond to the question? The other one is a comment.
Thank you very much, just Chinengo, on the comments and the issue you are raising. Yes, it is by the nature of the process in the electoral process that the courts are at the tail end, and at the end of the day, the courts are the ones which are blamed for all manner of errors that have been committed by other people elsewhere. Yesterday, we were talking about the social media abuses, how that judges for not, allegedly not doing the right thing. When in actual sense that the problem is elsewhere. How many times have accused persons been taken to court and no proper evidence has been tendered? And when you release that person, the court is saying, look, you are corrupt. You must have been bribed to release that. Yesterday, we talked about a way of the court finding a means of informing the public about what the cases are about. And I liked the presentation by our sister from Zambia this morning, that let's make our judgments as clear as possible for even the ordinary person to read and understand what the issues are. But besides that, ZJ, when I was in the office, we established a directorate of communication. And I said, let's employ a communication expert who will be able to get the judgments and get a summary of the judgments that he can give to the public. Particularly so, like a page or two. I know the courts give press summaries of the long judgments, but the communication people are very well trained in that, and they can be able to capture some of the points so that they give them to the public. In the event you are attacked, that your judgment doesn't make sense, that summary can even be released to the social media, and the public will see where the problem is. So it is something that we need to do. One thing we have got to understand is that we are serving a very enlightened society. Very, very enlightened society. You're not going to fool people. And even if you do, you are not going to fool them forever. You are not going to fool people forever. We have cases where, because some judge is deciding some case on some extraneous factors, comes up with what some people have called judicial sophistry, intellectual sophistry. You argue, but any lawyer reading through that judgment will see that you are even yourself struggling to make a point which is not there. So what I'm saying, ladies and gentlemen, is that some of these things will get to a point that they will catch up with whoever is doing that. You can fool people, but you can't fool people forever. You can't fool people forever. Defending the judicial space, that's where the CJ, in my country, they say that the Chief Justice is the political head of the judiciary. So sometimes they should answer to those political political allegations. For example, if a judge is attacked, he can't talk for himself. The CJ has got to talk on his behalf. Of course, after establishing that he is being accused falsely, is even if he's not being accused falsely, for the good of the image, he should find a way of saying, look, you can't attack a judge like that. If you have evidence against him, there are channels to deal with such a problem. So the defending our space is not an easy issue. It's not an easy issue because of the way we operate. But somehow we should come up very, very strongly and defend our space. After all, we have constitutional authority that these other two arms of government have. The burden of proof, evidential. Somebody asked it later, early in the morning, when does it shift to the Electoral Commission, for example? It all depends. There is no fixed rule. It all depends on the evidence that has been tendered. You heard about judges of the High Court asking about some ballot papers with serial numbers which were not tallying. And that's what we did. The serial numbers we were shown on some ballot papers didn't look the same as those in other parts of the country. And we were saying, look, these ballot papers were printed by one printer. How come these ones are different from the other ones? Who is better placed to answer that question? It is the Electoral Commission. A petitioner has placed before the court a fact that there is some anomaly here. It is the Electoral Commission. That's when we say that the evidential burden shifts to the other side. I think I've responded.
Thank you, my lord. Is there another comment or question? I'm not seeing hands beside. Yes, over there. You mention your name and where you come from, and then you comment or ask a question.
Thank you, Chief Justice. My name is Lawrence Lunguzi. I am from Malawi Electoral Commission. I would like to thank the Emeritus Chief Justice for the very nice presentation, very clear. But I wanted to seek clarification on something that he mentioned. My lord, you talked about the power that the Chief Justice in Kenya has upon receiving a petition to advise the president to dissolve parliament because there's no balance in gender in the vote. Now, without undermining the fight for equality, I wanted to seek your views on how this bodes with the principle of separation of powers between the judiciary and the legislature, because I'm thinking, unlike in a situation where there's an issue of irregularities in an election, this is where people have freely chosen, but they haven't chosen the way the law requires them to choose. Now, here people have voted and the Chief Justice sitting alone decides to say, well, Mr. President, dissolve Parliament, let them try again. Now, my question is, how many chances is the Chief Justice given to advise the President to dissolve Parliament? What if you give the advice, the vote comes again, it's the same? Another petition, where do you draw the line? And I wanted to seek your views, whether you feel that power is democratic. Thank you, my lord.
May you respond, Chief Justice?
Yes, thank you. I'm sorry, because of I was rushing. I was racing with time. It is my mistake. It's not yours. I didn't make it clear. Upon the promulgation of the Constitution, one of the major issues that was there is gender balance. Gender balance, not only in the elected positions, but even in the government slots. So there is a provision in the Constitution that not more than 2/3 from the same gender can occupy appointive positions and elective positions. In other words, if it is the judiciary has to make sure that at least 1/3, at the very least, at least 1/3 are from another gender. If it is only ladies, men should not be shut out, and vice versa. Now, somebody talked about merit. I don't know about your countries, but we have situations where some very brilliant ladies are shut out simply because they don't sing the tune and things like that. So the Constitution itself requires the country and all institutions of government to ensure that at least not more than 2/3 of the employees, like now in the Kenyan Supreme Court, there was a big issue about only men there and only 1 or 2 women being in the Supreme Court. But that was corrected. So the issue about even gender balance, we have even in Kenya, because of the ethnic tensions, we have that same provision requiring that there should be regional balance. The issue that comes in is the question of merit. Are you going to pick somebody to come and get into a position he or she doesn't qualify for? The Constitution is still very clear. The first point of consideration is merit, and thereafter, then you must have that balance. So this provision regarding gender, it required Parliament within 5 years of its of the promulgation of the Constitution to enact legislation that would facilitate that gender balance. I believe the makers of the Constitution had in mind things like the proportional representation that is there in Rwanda and other countries. Parliament, for more than 10 years, refused to do that. In fact, acts were brought, and sometimes you would even see some, what do I call it? Laxacidal proceedings where the parliamentarians are not serious. And when it comes, surprisingly, one of those bills came and the members of parliament of the female gender themselves were not keen to want to support it. Yeah? And so it failed. So the provision is to the Chief Justice to consider petitions brought to him. You asked about separation of powers. The Chief Justice is not going to come out of the blues and give that opinion. It is upon petitions being sent to him. And of course, you deal with it like any other case. I gave both sides an opportunity. They made representations, and I made out an advisory opinion. It has not been challenged, but though you had better know that it has not been challenged. But the executive didn't comply with it. But the point was made. And by the way, I think somebody has said, but I don't have, but I mean details, that it has in one way or the other, it is in the minds of the powers that are there to make sure that the balance is there. Thank you.
Yes, another question or comment?
This one.
Which one? Oh, yeah. Let me have your name
switch
and where you come from.
Yes.
Okay. Thank you so much. Honorable Chief Justice Baraga. Just as a point of reflection, which I think this kind of gatherings.
Can we have your name again?
I'm Justice Kachale from Malawi. One observation, I think this kind of gatherings never adequately reflect upon, and I wanted to hear your comments, my Lord Chief Justice Baraga. You've talked about the challenges of a system that is corrupt. And in this context, the corruption manifests a fundamental societal challenge where people are inclined to believe that to do politics, you must buy votes and do this and do that. And I don't imagine that that conduct spares the judiciary. How much, in the spirit of transparency and accountability, how much as an institution can the judiciary do to ensure that not only are the people sitting on the bench technically competent and proficient to administer justice, but they also have the moral backbone to resist the temptations that come with the office? Because the fact that you are the one who is going to determine that petition that sees somebody assume that high office must necessarily mean that you are not insulated from the attempts to corrupt and compromise you. How can we deliberately create a body of people who not only have the technical competence, but also carry with them the moral backbone to be people who can be trusted to safeguard the constitutional guarantees and values that we all agree our societies need?
Respond. Thank you, Judge. I didn't get your name, but I can answer the question. It's a difficult question to answer because it is actually individual. What I would say is that that issue is supposed to be dealt with at the point of recruitment. The point of recruitment, and it also depends upon the provisions in the Constitution about the recruitment. We have had challenges. By the way, Kenya, when you see the kind of problems we have handled, please bear in mind our history. We have had very many interesting situations that some provisions have had to be put in the Constitution to take care of those situations. In our previous Constitution, the power to appoint the Chief Justice was solely with the President. The President would wake up one morning and appoint somebody. Of course, there was provision that he would do that on the advice of the Judicial Service Commission, but we know it as a fact that in practice, the President would just say, look, I want to appoint so and so. Do you have any objection? And of course, the Judicial Service Commission, especially at that time, would just say, no, that's okay. And it's appointed. Come down under the new constitution, and I've looked at the other constitutions. Ours is a little unique, by the way, because, as I said, because of the history we have had. We had presidents pick anybody to become Chief Justice, and the problems followed with that. So under our law, the Constitution requires competitive recruitment of all judges and the Chief Justice as well. And once the Judicial Service Commission has interviewed, and these interviews are public, especially for the Chief Justice, they are televised live. Once that has been done, the President is required to appoint the person nominated by the Judicial Service Commission. The Judicial Service Commission does not give 2 names or 3 to the President. It gives only 1. Whoever, came first in the interview. If, and that has not happened, if the President doesn't appoint, they will have to go back And now it is the Judicial Service Commission that will now decide. So the provision in the Constitution is that the president shall appoint the Chief Justice in accordance with, not with on the advice, in accordance with the advice of the Judicial Service Commission. And that was an issue in Parliament, in court. It was decided that it is the Judicial Service Commission which appoints the judge or the Chief Justice. So the president's role is ceremonial. So that's why now in the course of the appointment, where you raise the issues of moral standing and even competence, that's where the Judicial Service Commission is supposed to deal with. The law requires that the persons who have been shortlisted for interview, the Judicial Service Commission is supposed to do some background check to ensure that you are not recruiting or you are not even interviewing somebody who is involved in moral scandals and things like that, and or who is not competent. So that is the role of the Judicial Service Commission. It's supposed to deal with that, so that the person who is interviewed at least goes through that sieve and is there. Of course, you can't be 100% sure that this is the right person you have, but of course it's a step. For example, if you nominated some people and there is anybody has information about the past record of this person, you can go to court and stop that person from being interviewed. And that process itself, I can tell you that has stopped quite a number of people from applying. Because they said, look, I don't want to be taken through that public screening for that position. That position can stay. So that is how I think it can best be dealt with. But as I said, there is no system which is perfect. No, I don't know. Yes, okay.
I'll give you the opportunity to two others to comment or make a comment. Yes, my lord.
Yes, Justice Kachalo actually raises a very important matter, and I completely endorse what Chief Justice Maraga said, that really there is no 100% foolproof system. But the process of appointment, I believe, the more transparent it is, the more it gives us the chance to reduce chances of making wrong appointments. Back home, the Constitution states that the person must be fit and proper, and courts have gone out of the way to interpret that, fit and proper. So the process has got to be transparent. Back home, the interviews are televised and the process is very, very rigorous, and the public is actually invited to make comments. But as I say, there's no foolproof system. But the more transparent the process is, the more chances are that we could cut out a lot of wrong appointments. Thank you.
Thank you, my lord. There was a hand at the back. Do you still wish to comment or ask any question at the back?
Boa tarde.
I cannot see the hand.
Boa tarde. Meu nome é Sônia Uxanga. Venho de Moçambique. Queria parabenizar o apresentador pela linda explanação. Durante a apresentação, percebi uma parte que tem a ver com a corte da corrente elétrica durante a contagem de votos. Essa prática é tão frequente em Moçambique e chega a ser preocupante, porque de uma ou de outra forma mancha aquela fase da contagem, beneficiando um em detrimento do outro. Perante essa frequente corte, naquela fase de contagem de votos, eu acho que é algo propositado, porque não se justifica em maior parte do país, naquele dia mesmo da votação, ter a corrente elétrica durante o dia e no momento da contagem haver cortes. Eu gostaria de saber o que é necessário fazer para minimizar esta prática, de forma a garantir a tão almejada justiça eleitoral. Obrigada.
Well, did you hear that? Can you respond?
Thank you, Madam, for this. I stood up so that I can also make the final remark. Our country, as I said, has gone through some very unpleasant history. That has necessitated the change in the law. Unpleasant history, you know what happened in 2007, 2008. And the judiciary was blamed. Although, of course, not entirely, it was not entirely the one to blame. We need to avoid that. So, Madam, what happened is, because of those challenges of collecting the ballot papers in boxes to one center for counting, and there was a lot of rigging that was done in the transportation. Some of the polling stations were very far from the polling center. Assume it is here. I don't know how the geography of this country. Yeah, I assume the polling center is here in Victoria Falls town. And there are some areas, not even very far from here, where the road is very bad and almost inaccessible. And vehicles were said to get stuck in the road, get stuck in quotes when very many things were done. And because of that, people were returned as elected, who even the people themselves say, no. This fellow could not have scored the votes he got. So how do you deal with these? Amendments were done to the law to make sure that the counting is done in the polling stations. The polling station, by the way, you could have a school where you have very, very many registered voters. You will go and say the names starting from N and M. If there are very many, you give them a stream, a class. That class is designated a polling station. Are you getting me? That class of the names starting with M, mine starts with M. If there are many enough, is designated a polling station. And a polling station should not have more than 700 people. All that is intended to make sure that the counting is completed within a very short time. How long would it take to what? to check, scrutinize the ballot papers and separate them and count 700 of them. It won't take very long when the Electoral Commission is doing its work well. So that's why we say that it's a polling station. So you can have one school having even 5 polling stations. And the results recorded from there are final. The Electoral Commission cannot change. They used to have powers to change, but they can't change now. It is only those ones. And when you complete and put them in that form, which you call it, that is the form now you transmit. So that when you go later with the original form, if it doesn't tally, you have got an explanation to make. Because this one which you have tallied and you have recorded, you're supposed to show it to the agents. Say so and so got so many, so and so got so many. Are you okay? Sign here, we transmit. And they transmit. Sometimes those agents, especially those of the losing candidates, walk away. But the people are there, and it's supposed, this form is supposed to be even pasted on the wall. So those are among the issues that we have had to deal with. Justin, somebody talked about this being a regional body, from which you can develop some regulations or some guidelines. I agree with him entirely. When it comes from, I think it was that gentleman from Arusha who talked on virtual. The judiciaries, as I said, have got to understand, the judges have got to understand their role. One writer said that the major role of a judge in a democracy is to defend democracy. That's your foremost role as a judge, is to defend democracy. And I agree with him. If there are chaos, and I tell lawyers, if there are chaos regarding, there is the country, the military have come in, among the first people to be jobless are lawyers. Doctors, if there are injuries, they will still have people to treat. But the lawyers are among the first ones to go out of business. So it is in our interest. It is in our interest to make sure that the rule of law is followed. So my suggestion on this, Justin, if we come to a symposium like this one, don't go allowing presentations on academic papers. I'm not saying there is anything wrong about academic papers, especially if somebody is dealing with a novel idea. If somebody has statistics like Dr. Atlosa had yesterday. But to come here and say and begin making a presentation on what a standard of proof means, what a burden of proof means, is for me is not worthy. You're preaching to the converted. You're preaching. You are telling people what they have learned all along, what they have dealt with all along. When we come to a forum like this, let our focus be on what experiences can we share from this jurisdiction, from that jurisdiction. What problems did you have? Like we have explained in Kenya how we have come to where we are. And we have a lot of challenges, by the way. We are not yet there. We have a lot of challenges. So that you share those challenges. I was in one jurisdiction when I was Chief Justice, and I was told that the judges have an annual judges conference. One of the greatest issues or fear of every judge is that conference, because of the peer pressure. You write a ridiculous judgment, my friend, you will be torn into pieces by your own what? Your own colleagues, because according to them, you are doing disservice first and foremost to the country and to the judiciary itself. You are undermining the role of the judiciary. They will question you, because your colleagues, they understand that what I was talking about, intellectual sophistry, they can see through. They can when the facts of the case cannot lead to the conclusion you are having, they will see through. So if we can change our focus, give those intellectual points when you are establishing the like the base, the foundation of your what, of your presentation, but to go to the practical issues. Thank you.
Thank you very much, my lord. Can we give him again a big applause? Program Director. Yes. Thank you for giving us the opportunity for me to chair and for my Lord the Chief Justice to make a presentation. We thank you. I think you can be excused now.
Thank you. You are totally quite excused, and thank you very much. You finished. You finished at 4, which is good. Thank you, Chief Justice. So we are running a little bit out of time. We should actually be closing now, but with your indulgence, I was going to tweak a little bit that you just take a 10-minute breather and then come for the closing session. You want us to just go? There is a document I've prepared around the key observations. I have not tested it with the authorities. So if we proceed now and say this is what the conference final position is, I run a risk of overreaching my my authority. So what I just wanted was to give them just 10 minutes just to go through what I've drafted, and then when we come, we get into closure. I present, and then we get into closure. With your indulgence, it's a really due process issue. Thank you. So 10 minutes. Hello, colleagues from the JSC, please, can you help us get the people back here? Yeah. Yeah, but you don't. So thank you. Welcome back. We are now moving towards the closing session of our wonderful conference. I really want to thank all of you for your participation. The way we are going to structure it, because we've had to collapse two sessions into one, is for me just to give you a sense of the key issues that emerged in the past 2 days of this meeting. There's been a rapporteuring team led by Dr. Katsande that has actually produced this very rough draft. We've had so much volume of information that we will need to process to be able to come up with actually the final document. But this is really in the interest of transparency for you to get a sense of what is likely to be in the final document or some form of communique for this meeting. After I do that, I'm going to then invite the Deputy Chief Justice, Justice Gwaunza, to say a few remarks in closure. And then I'll then ask the chairperson of the Africa Electoral Justice Network, Justice Mba, to then give us his remarks to send us off. And then we will then get, I think, Dr. Kasande giving some information about logistics and the way forward. So in terms of the key findings that the rapporteuring team found, they classified their findings along the sessions being the problem areas, identifying what they thought were the key problems arising from the conversations, from the presentations, and what looked like recommendation or action points that could then inform the future work of the Africa Electoral Justice Network. So the first one really is to accept that the meeting ran under the theme of turning the hope of the African Charter. Is it being followed? Oh, so I'm not rolling it. You don't mind, I can just ramble through. Turning the hope of the African Charter on democracy, elections, and governance to action, and the role of the judiciary in upholding the rule of law and ensuring free, fair, and credible elections in Africa. The first area of reflection was on constitutionalism, good governance, and electoral justice. Some of the problems that the rapporteuring team had from ourselves as we deliberated was that we have weak or not adequately capacitated constitutional institutions of protection of human rights. And it's a very broad phrase to include courts, to include commissions, human rights commissions, etc. There is also the question of corruption that has eroded or corroded the systems of accountable governance. There's also the politicization of the judiciary, sometimes through the filing of spurious electoral challenges and petitions, and then threats against civic space, and in some states, the undermining of fundamental human rights. Those are problems that affect good governance, constitutionalism, and electoral justice. The rapporteuring team felt in our discussions that some of the solutions to deal with those would include dissemination and implementation of the principles and guidelines for the use of digital and social media in elections in Africa, which were produced in 2023. There was also the need for strengthening judicial and legal protection of fundamental rights during the entire election cycle. Dr. Matlosa gave us a lesson on the election cycle that, as Chief Justice Maraga said, the petitions or the EDR comes at the tail end and not necessarily involving the entire election cycle. And then the need for judiciary working with other critical players in the justice delivery chain to collaborate in tackling corruption, and then increasing awareness of the key players in the electoral justice ecosystem of the African Union standards governing democratic elections through continuous judicial and legal education and appropriate symposia, as we have done now, taking advantage of the African Charter on democracy, elections, and governance as an instrument to increase our awareness of standards that have been developed by our heads of state to try and improve the democratization agenda in Africa. And then the second part was segment was on protecting independence and impartiality of the judiciary during elections. So the problems rapporteured or identified by our rapporteurs were that elections are a threat multiplier to judicial independence, that there's in some instances lack of judicial independence in electoral litigation. There's also the high case pendency, too many cases that are pending in electoral disputes and clogging the court system, resulting in delays in the finalization and the development of negative perceptions by the public about the judicial capacity to resolve cases. Then there's also the scandalization of courts adjudication electoral disputes through social media. And then the lack of financial resources by judiciaries to fund their operations, thereby subjecting them to the whims of the executive or political authorities. And then also some interference with the judiciary, sometimes by the executive or other forces with power so to do. And then the resolutions in this program area was that there's need to develop strategies to ensure that judges presiding in electoral courts enjoy both institutional and decisional independence from any extrinsic political or economic or unlawful pressure brought to bear upon legitimate exercise of their judicial discretion and authority. Judiciaries have their own independent budgetary allocations to run their operations independent of other branches of government control. Then the strengthening of judicial capacity to resolve election-related disputes expeditiously, independently, and impartially. And then the need for voter education, especially by civil society, and conscientization on the role of the judiciary in the electoral process, as well as the availability of alternative dispute resolution methods, so as to reduce the level of expectation for the judiciary to resolve what may be political rather than judicial cases. And then increasing the networking, collaboration, and exchange of information and resources among electoral judges and electoral justice experts in Africa. The third area, which is a potential area of programming, is about the role of civil society in advancing human rights and good governance through electoral justice. And the problems there were seen as weak and underfunded and under-resourced civil society, threats to civic space due to the democratic erosion, democratic decay that Dr. Matlusa talked about, lack of regional standards in the determination of the burden and standard of proof in electoral litigation, and then lack of good governance and proper administrative structures in a number of election management bodies. How to do anything, the action-oriented reaction to it was that we need to use alternative election dispute resolution by judiciaries to expedite the resolution of electoral disputes, to develop and maintain a database of jurisprudence codifying best practices and in matters of electoral justice, dealing with such issues as procedural issues that are impacting on election litigation, as well as standards on the jurisprudence as it relates to things like the burden of proof. There's need for research, study, analysis, and documentation of key judgments on electoral justice by African judiciaries in order to safeguard and strengthen electoral justice in Africa. And the example given by Dr. Matlosa was the need to study, analyze, document the Malawi and Kenyan experiences as part of that safeguarding process. Then member states should ensure that bodies in charge of electoral processes conduct elections in a manner which is in full compliance with the Constitution and existing legal framework and the principles of electoral transparency. And then in appropriate situations, civil society should approach courts as amicus to enrich the development of African jurisprudence that is consistent with the African standards governing democratic elections. Then on transparency measures in electoral justice to deliver justice for the citizens, the problems were seen as lack of information to electoral litigants on the status and outcomes of cases pending before the courts, and lack of mechanisms to provide access to information to the public, and then lack of uniformity in electoral jurisprudence among member states, where the solution orientation is towards judiciaries that need to be proactive by taking deliberate steps to fight misinformation and disinformation, making use of case summaries for the media, establishing a communication structure and social media platforms that communicate with the public in order to proactively share information and minimize the negative impact of disinformation. Then member states need to actively promote regional collaboration through the sharing of jurisprudence by means of regional bench books, compendia, or electoral justice workshops. And then the next area of potential problems or programming is the African Charter on Democracy, Elections and Good Governance as a tool of entrenching universal values on human rights in electoral justice, in particular promoting women's effective participation and inclusion in politics and leadership. The problem is the lack of effective women participation in significant electoral and political spheres, and the non-domestication of regional instruments that have been adopted to promote women's effective participation in electoral political processes, as we heard from the experts who were talking about the dualism in states where there's need for domestication. The potential programming that could arise from a network perspective on this is that there could be a campaign for domestication of regional instruments that have been adopted to eliminate all forms of discrimination against women on the African continent. Then there could also be civil society that can monitor intra-party democracy and to analyze the level of institutionalization of political parties so as to reduce the contagion effect of lack of intra-party democracy that then results in the oversupply of unnecessary litigation of politics through the court system. Then there is also the question of development of guidelines to help judiciaries to protect the right to effective participation and inclusion of women in politics and leadership. This is why I'm happy that we have some women human rights defender groups here that could take advantage to partner with the Africa Electoral Justice Network to develop appropriate guidelines that can be the basis for continuous judicial education. So we are going to develop the area of the role of judges in protecting free voting that Justice Maraga spoke to. And we will use your paper and your recommendations to then fill it up. But otherwise, I think this is a snippet of what the rapporteurs found to be the key problem areas, where they then provided action-oriented suggestions of what the network could do in order to program with the members to resolve some of these problems and improve our democracy in Africa. So I think with those remarks, I don't know whether there's anyone who wants to quickly react. We are running out of time, but Chief Justice Malaba.
Just quickly, I think unless I didn't hear you properly, I don't think it would be correct to proceed from the position that there are weak institutions, judiciary institutions. Is that what you said? I don't think that would be correct.
Yes, so we could change it, but I said,
yeah,
let me make a concession. I said
we should not proceed on that basis at all.
Okay.
Otherwise,
it's a bit negative. I see. We should actually say strengthening of judiciaries rather than
need to strengthen.
Yeah. So
there's need to strengthen.
Strengthen. I totally agree.
Otherwise, we will have no job.
Yeah. Plus, you know, I come from civil.
In terms of the constitution,
no, it's true.
We exist in terms of constitutions, and we are there as institutions of the constitution. So we are there. We are performing. Otherwise, we can't start by saying there are weak institutions of the judiciary. I don't think that is correct.
Point taken.
Also, that I think there's also this wrong perception to say you start from saying there's lack of independence of the judiciary involved in the electoral processes. I don't think it's correct. I think it would be a wrong perception. There may be certain issues which arise in particular cases.
Yeah.
But once you start as a matter of description of institutions like that, then we are losing the basis on which these institutions exist. We are very conscious as judges that we act independently, we act in terms of the law and enforce the law. So that is where we should start from.
I totally concede. So I think the question of an appreciative inquiry where we appreciate that we have institutions. And this has been strengthening from the post-colonial era. They continue strengthening. And then, but we need to keep strengthening them. But the idea of presenting like the weak institutions or the lack independence, I agree. It can create.
Because if we don't do that, we are falling into the very trap that we are trying to get away from. Of other people labeling African judiciaries And Africa as a whole is just another thing that you can forget. There are no values.
Precisely.
We shouldn't do that.
So I've just presented what the rapporteur has picked,
Yes,
and then
they should be
we're going to, and it's an internal document. This is
I'm just raising this so that we spruce
to
it
improve all of
properly.
us. Yes.
Then lastly, I think we should also not approach, I don't think the intention by our friend, the professor, to have a study of the decisions of the Kenya and Malawi was meant to make those standard decisions for the judiciaries. Because we should not create an impression that judges should only be looked at as having made correct decisions when they set aside elections, when they set aside elections in petitions. We should base it on the basis that judges should rule on the basis of evidence that is placed before them. So this impression that Kenya and Malawi should be the prototype cases of study, if they are meant to mean that we should ignore evidence and seek to set aside elections because Kenya and because that's the best thing to do, I don't think that would be correct. I think Kenya and Malawi did that because of the evidence that was before them. And that evidence will not be before other courts. For example, it was not before the Zimbabwean case. A Zimbabwean case had all the V11s which were there by the Electoral Commission. This is what Justice Maraga was illustrating, that these are documents which are generated at polling stations, and they are filled, signed by the agents and everybody involved at a polling station. And they are placed outside the polling station for everybody to see. So if you take a petition to a court, you need to produce those to show that those that were there are not the same as those that were produced, and you seek to produce them. So if you can't produce those V11, that is evidence which is missing. And that was not there in Kenya. That was not there in Malawi. That is the basis of the differences. So we shouldn't create.
Yeah,
we
I
shouldn't
totally
create
agree,
that
CJ.
impression.
If you see the way, in fact, I worded it. The way it has been worded, the Kenyan was given as an example, but the substantive messages, research, study, analysis, documentation of key judgments on electoral justice in Africa in order to safeguard and strengthen electoral justice, full stop. To then say, for example, I was now trying to, I think the team was now trying to defer to the examples given, but I don't think the principle of research, documentation, and safeguarding electoral justice should fall on the sort of the example that they gave. So I think we will expunge the examples so that we stick to your principle that we safeguard elections based on evidence, based on African standards, and then improve the continent that way. Any other reaction, Judge Chinengo? Thank you, CJ.
It's just to observe what you called the second part, where you talked about protecting judicial independence, and you link it with too many cases, scandalization of courts, interference. I think in that communique, we must be careful with judges to show, not to show that we are averse to criticism. So while we can talk about too many cases, we can talk about scandalization of judges or the judiciaries and interference and so on, we must remain alive to the fact that people have a right to criticize us when we are not doing right. So I'm just saying that balance must be properly kept. Otherwise, you give the impression that judiciaries are being overprotective of what they are doing.
So let me emphasize that I've just read the initial draft from the rapporteurs. There's going to be a team involving myself, the Africa Electoral Justice Network, and the organizing committee that is going to come up with a proper concluding statement. So as of now, these are the areas of discussion, but the content of what is going to be produced is not there. I don't have it. I've just simply read something out to you. So what I want to encourage now, moving from this advisory guidelines from the Chief Justice and also Justice Chinengo, is there anything that is missing at the substantive level? I just want to give maybe 2 or 3 people to speak about what is missing rather than the guidelines on direction. We've accepted it, but anything that you feel is missing? 1. We go twice. Then we go 3. So the substantive content will be looked at, then the specific drafting will be left to the organizing team of Africa Electoral Justice Network and the local organizing committee. And then it will then be approved by our leadership, and then it becomes final. So otherwise, thank you very much. Let me take this opportunity now to invite the Deputy Chief Justice, Honorable Justice Gwaunza. You can actually use that mic if you want. The mic, the podium. That podium there to say your remarks.
Thank you, Director of Ceremonies. Good afternoon to all, if you are awake. Esteemed Chief Justices in attendance, honorable judges, distinguished and honored guests, ladies and gentlemen, I go along with the protocol that was established yesterday. I'm honored to stand here before you to deliver a vote of thanks. This is an easy task for me. On behalf of the JSC and all the esteemed participants at this momentous symposium, as we draw close to our program. It is with a profound sense of appreciation that we draw the curtains on this important gathering. The event has been a beacon of entitlement, of enlightenment, fostering as it did discussions crucial to the future of democracy and electoral justice on our continent. The essence of this symposium extended beyond the confines of mere academic and theoretical discussions. It has not only served as a dynamic platform for reinforcing the ideals that are embedded in the African Charter on Elections, Democracy, and Governance, it has also taken a holistic approach in emphasizing the pivotal role of regional collaboration among African judges. Our collective journey over the past few days has been intellectually stimulating, I'm sure you'll agree with me, enlightening and inspirational. The depth of discourse and the exchange of ideas have undoubtedly enriched our understanding of the crucial and critical issues surrounding constitutionalism, good governance, and electoral justice. the very foundations upon which the ideal of a thriving democracy is built. Esteemed participants are aware that the essence of our gathering revolved around insightful sessions that analyzed and discussed critical aspects of electoral justice, governance, and the judiciary's role in all of this. We've collectively recognized that adherence to minimum standards of constitutionalism is not merely a legal requirement, but is a fundamental necessity for democracy to flourish. It is this adherence that ensures the sanctity of our electoral processes, guaranteeing them to be free, fair, and credible. And the judiciary, which faces increasing challenges to its integrity during national elections, was a focal point of our discussions. I think we had and discussed a lot around this particular issue, which actually was the theme or part of the theme of the symposium. The importance of transparency in decision-making and the adjudication of election disputes was thus a central theme. Practices to boost transparency, such as televised hearings of petitions and judgments, engagement with civil society organizations, and crafting clear and straightforward judgments were shared. Innovative approaches to building trust in the election adjudication process were identified. We also had discussions centered on overcoming barriers faced by women and other marginalized groups in and during elections. I think we had a very stimulating session on which this issue was discussed. When examining the challenges posed by the misuse of state resources and vote buying, it became clear that electoral courts judges play a pivotal role in safeguarding the integrity of our democratic processes. It is our collective responsibility as guardians of justice to translate these discussions into actionable steps that will fortify the rule of law and enhance the democratic processes in our nations. And as we collectively navigate these challenges, it is essential to acknowledge the gravity of the task at hand. I don't think that anyone, or at least talking of the judges and judiciary, fails to appreciate that important point. It is essential to acknowledge the gravity of the task at hand and to recognize the dedication of those working tirelessly to protect the foundations of our democracy. Therefore, let us carry forth the knowledge gained and the discussions held into our respective spheres of influence. On behalf of the hosts to this event, I extend deep gratitude towards all those who made the many brilliant presentations that we listened to, those who contributed to the debate at hand, those who moderated at the various sessions of the symposium, and generally attended to all issues within and without the hotel that contributed to the success of this event. Your insights, wisdom, and unwavering commitment to the cause of electoral justice have added immeasurable value to our discussions. I don't know why it felt for a moment that the microphone was not picking up on my voice. In particular, I wish to acknowledge the Electoral Justice Network, the AEJN, for having had faith in our JSC's capacity to hold this event. As a country, as Zimbabwe, we are proud to have successfully hosted this event. To that end, I must also express our gratitude to the Secretary of the JSC and members of the Secretariat, for their exceptional services throughout this enlightening gathering. This encompass the protocol officers, the drivers, and all other support staff. Their services have not only contributed to this event being a resounding success, they've also served as a shining example of the Zimbabwean hospitality. Allow me, finally, to single out the extra curial events, if I may put it that way, that saw our distinguished visitors and participants experience the breathtaking wonders of the world-acclaimed Victoria Falls and the spectacular rainforest. I do not forget the novelty and exhilaration experienced at the Boma restaurant last night. And this included the very delicious food, the drums that we were expertly drumming on, and not to mention some dance steps that could be seen here and there. All was fully appreciated. It is noteworthy to mention that the JSC personnel, being senior administrative officials, made significant sacrifices to ensure the success of this event. So their dedication and commitment to duty cannot be overlooked, as it stood as testament to the spirit of collaboration and excellence that defines our nation. Lastly, sincere appreciation and gratitude are extended to the hotel management and staff who proffered the warmest welcome and hospitality towards us in different ways throughout our stay at the hotel. Fully appreciated were their professional and tireless efforts to ensure optimum comfort was enjoyed by all. This gracious welcome fostered a collegial atmosphere which allowed us to engage in meaningful discussions on issues crucial to the effective administration of electoral justice. To sum up, let us leave this forum not just with a wealth of knowledge, but with a renewed commitment to upholding the principles that we've discussed during the last 2 days. As we bid each other farewell, I invite you to carry the spirit of these discussions back to your respective home countries. May the lessons learned and the connections made during this meeting serve as catalysts for positive change in our respective jurisdictions. In addition, may the bonds forged transcend this conference, fostering collaboration and strengthening the fabric of justice across our great continent. I look forward to witnessing increased collaboration amongst African judiciaries as we continue to work together towards a future where democracy, good governance, and justice flourish across our continent. I thank you, and may the spirit of justice guide all our endeavors. Thank you.
Thank you very much, DCJ, for those warm words, and for reminding us that yesterday our leaders in the region, judicial leaders, were playing drums. I think I could see that it really amounted to a lot of gymming and training, which was a wellness exercise. May I invite our leader at the Africa Electoral Justice Network, Justice Mba, and who inspired us to have this meeting here and approach the Chief Justice to come and say his remarks. Thank you.
Thanks, Arnold. Let me start off by telling you that you have been such a wonderful bunch. To that extent, I ask that you give yourself a round of applause. Just a few remarks. CJ Maraga, the points that you made, the suggestions that you made, the proposals that you made are on point. And I want to assure you that they are actually forming the basis upon which this movement was founded. We are seeking to establish peer monitoring mechanisms, increased collaboration among various judiciaries across the continent. We are seeking to foster an approach to a common jurisprudence insofar as electoral justice is concerned. One of the aims and objectives are that we will be looking, actually we have started looking at an election digest bench book, a compendium that is forming an election judgments database of all judgments across Africa on electoral justice. So your suggestions are much appreciated. As I explained yesterday, we have now formalized our structure. We have adopted a constitution that will serve as a guide. From 2019, we have been operating rather loosely, and now I think we are now properly structured. We have been having some activities just to, other than the annual meetings. Like I said, we first met in 2019 in Johannesburg. We then met in Malawi in 2022. Of course, we were interrupted by COVID, but we met in Malawi, and then this is our third meeting. But in between, we've had some activities. I may mention two specifically. On the 24th of May, 2023, we organized quite a large webinar where we were reflecting on the recent elections then in Kenya and Nigeria. And the webinar was focused on that. And then on the 30th of November, 2023, we had another webinar where we were dealing with the role of judges in addressing disinformation during elections. We also dealt with evidentiary rules and the burden of proofs, just a general discussion. And because the really at the center of this organization is empowerment of ourselves. Empowerment of ourselves. We should be better poised to serve our people, to deliver electoral justice more effectively. That is really at the heart of this movement. I wish to extend thanks and gratitude, firstly to Chief Justice Malaba and the judiciary of Zimbabwe, who co-hosted. I wish to extend a word of appreciation to the JSC of Zimbabwe, the local organizing committee. I mentioned Walter, Dr. Katsande, Faith. Thank you, thank you. In Xhosa, we say, Nangomso. I wish to extend a word of appreciation to the leadership of various judiciaries, the Chief Justices who've been with us, CJ Mapalala, CJ Malila, CJ Maraga. I need also mention that last year in Arusha, when the Chief Justice Forum met, we were given an opportunity to present ourselves as the network, and we were launched and we were received warmly, and we continue to enjoy the support of the leadership of our judiciaries. Thank you for that. Next, I wish to thank members of the working group of the network. I did present their names to you yesterday for the sterling work they did in putting together this symposium. I must also thank our partners, our strategic partners, who have been with us all the way. AJJF, Chief Justice Cheneng was the president. He also addressed us. Also, Sir J. Now, we are still a new organization. We don't have resources. So the strategic partners are assisting us in providing us with secretariat support. So I think you should know that. I must also thank all the resource persons, the speakers, the panelists who addressed us, very insightful talks, ideas. And then I must also thank all the participants, physical and online, who attended. And I'm sure you'll agree with me that the debate, discussions was very lively. I must apologize, though, that with the last session, there were slight technological problems, in particular with Ambassador Salah Hamad, but I think we were able to get to the gist of what the issue was. We had the two panelists, one of whom was Advocate Pensi Tlakola, and they addressed us properly, and I'm sure we learned a lot from what they had to say. The first thing we are going to do now that we are formalized, as soon as possible, probably within a week or so, the network will hold our debriefing session and start to plan, deal with all the takeaways, all the issues that have been raised. Thank you. Thank you. Please travel back home safely. I thank you.
Dr. Kapsande.
Thank you, Honorable Chief Justices, Honorable Judges, distinguished guests, ladies and gentlemen. I have an announcement to make regarding our departure, mainly for tomorrow. May we kindly note these departure arrangements. Firstly, for delegation departing for Harare tomorrow at 1100 hours on fast jet. Our protocol team will collect your bags at 8 a.m. From 8 a.m. to 8:30, protocol team will collect luggage 8 a.m. to 8:30, and vehicles ferrying delegates to the airport will depart the hotel at 11:30. This is for delegates that are on the 11 o'clock fast jets. Fast jet bags collected 8 to 8:30. This is for delegates who are on fast jets that leaves at 11 o'clock in the morning. Bags are collected between 8 and 8:30, and then you depart for the airport at 9:30. 9:30 in the morning. Thank you. And then secondly, for delegation departing for Lusaka through Livingstone tomorrow at 12:20, bags will be collected between 10:30 and 10:50, and will depart the hotel for the airport at 1100 hours. 12:20 flight through Livingstone, bags collected 10:30 to 10:50, and departure from the hotel is 1100 hours. And then for delegates, delegation departing from Johannesburg at 1400 hours. And also at 1410. So there are two flights that will be leaving for Johannesburg tomorrow at 1400 hours, and the other one will be leaving at 1410. Your luggage will be collected from 11 o'clock to 11:30, and then departure from the hotel to the airport is 12 noon. Then for delegation, departing for Harare at 15:15, 3:15. Departure 3:15. Bags will be collected at 1:15, that is 1500 hours, and then departure to the airport will be at 1400 hours at 2 p.m. And then for delegation departing for South Africa at 15:20 hours, that is 3:20 in the afternoon. Luggage will be collected from you at 1:45, this 12:45, and departure to the airport will be at 13:20 hours, 1:20 in the afternoon. That's the departure time. For delegates leaving for South Africa at 15:20, you depart the hotel at 13:20 hours. And then for delegation departing Livingstone Airport, departing from Livingstone Airport at 1800 hours, that is 6 p.m. This is now on the 4th of February. 4th of February, that will be on Sunday. They're on Kenyan Airways. Our protocol team will ferry you to the airport at 1500 hours. And then lastly, arrangements have been made for late checkout in respects of delegates that are flying out after 1000 hours in the morning. And then, sorry, I said lastly, but I still have another announcement to make. Dinner tonight is going to be in this very room, and it's starting at 7 p.m. Should I say another lastly? If anybody has lost, I think there's a laptop charger, and kindly come and see me so that you can be reunited with your loved ones. Thank you.
Thank you very much. Thanks to an end our program. But then I don't know whether Justice Mba, you want to say anything about the logo, but this is the logo that the Africa Electoral Justice Network chose during the events here. So very, very historic adoption of the statute and then adoption of the logo. So the foundation for electoral justice is rooted in Victoria Falls in Zimbabwe. Thank you very much.